disturbing sheep. The unauthorized construction application is to
Construction has to be demolished, Mr. R.
no, it was not order law. As per our
It's construction, Mr. R.
kind the grievance
Where is that item appearing?
664. 664.
Quickly list.
Upgradation, my lord.
Please come tomorrow.
My lord, this operation is state operation.
Yes. In the monthly list upgradation, yes.
You have been permitted to mention, my lord, item number 179, my lord. Today's list, my lord.
Yes.
My lord, it is under heading assigned matter, my lord. My lord, my extension is expired, my lord, in the end of July, my lord.
What expired?
Interim order, my lord.
Interim order.
Yes, my lord.
Oh, why did you not mention for extension?
Yes, my lord, it is but it is appearing on
Why did not mention for extension? Calcutta the extension of interim order.
Item number 97 of your lordship's daily list for upgradation.
Please come tomorrow. Yes, call the list.
My lord, I am for the petitioner, my lord. Here, my lord, the opposite party appearing and they have filed an application, my lord, to that effect for modifying the order, impugned order passed by the learned executing court. My lord, paragraph 10 onwards of their application.
So why it is appearing under the heading to be mentioned?
My lord, that can be disposed of, my lord.
No, why it is appearing under the heading to be mentioned? Why to be mentioned?
My lord, they have mentioned, my lord, for
Yes.
It is settled out of court, my lord.
It has been settled out of court.
my lord, the impugned order may be modified, my lord.
You have said it has been settled out of court. Then I'm
My
discussing
lord,
of recording that.
that's why, my lord, this application has been made. Actually, my lord, there is a compromise decree was passed, and the executing court passed the impugned order beyond the decree, my lord.
On the full schedule, my lord, of the plaintiff.
And prayer of the decree holder at page, my lord, 51 of the petition, my lord, revisional application, they have been made. It is said that.
That is the compromise.
One, my lord. Compromise.
That is the compromise.
Look, in can one, my lord, page
That is
12.
That is at page 12, yes. Where is the compromise? Order 23, rule 3.
My lord.
So you have filed before the learned trial, Judge.
My lord.
But this application cannot be taken up as there is an interim order.
My lord. My lord, that order may be modified, my lord, to that effect.
No. You have filed an application under Order 23, Rule 3 before the learned trial.
Lord, that compromise decree has been passed. After passing the compromise decree, the decree holder put the execution proceeding before the learned executing court, and executing court, my lord, without pass the impugned order beyond the decree, the compromise decree, and to that effect,
Full
at
schedule,
page,
my lord. That is
page
illegal.
51, my lord, in their reply, at paragraph 11, it is categorically stated that
Paragraph 11.
Paragraph 11. I say that there is a compromise decree between ourselves, decree holder, and the opposite party number 329, and as such, the learned court is required to execute the decree dated 13 January 2023 by
Is placed before the learned executing court.
I have that has been placed by
Show me from the impugned order that it was placed before the learned
my lord.
executing court.
That has not been considered, my lord.
Show me that you have placed that. Show me that you have
My
placed
lord,
that.
That is that, my lord. The second page. In the first
All right. list this matter.
But I prefer the opposite party, my lord.
Yes, why it was adjourned?
It is adjourned because the matter involved granting stay, refusal of stay in pendency of Section 5 application. I had relied upon 1984 Calcutta, and the court has referred that Justice Tandon has something considered. I found it out. Justice Tandon, sitting in single bench, considered that decision, but the facts of that case is quite distinct from this. In the case before
Yes,
Justice
when is the
Tandon,
section 5 application pending?
Section
For hearing?
application pending, my lord, before the title appeal court. Page 44, my lord.
Page?
Page 44, my lord. The petitioner previously filed one miscellaneous appeal.
Yes.
Stay was granted in the miscellaneous appeal. The respondent appears and raised the issue that order granting police help under Order 21 Rule 97 is not come under the purview of Order 43. Therefore, misappeal does not lie. Accordingly, misappeal was dismissed.
What is the order under challenge?
Order under challenge is, my lord, the impugned order dated 19th of May 2025, wherein when I filed.
Give me a minute, please. Give me. Is the application under section 5 pending?
Page 44, my lord.
When it is fixed for hearing?
Fixed for it.
It is fixed for hearing the next day in the title appeal. Right now I don't know, my lord. But the point, my lord, which is involved in the impugned order and which is my challenge hearing, that Order 41 Rule 5 cannot be granted in view of Order 41 Rule 3A when the Section 5 is there.
No,
But-
against which decree you have preferred a title appeal 37 of 2025?
Order passed under Order 21 Rule 97 is
Order 21 Rule 97 allowed?
allowed.
Allowed.
Against that a title appeal?
My lord,
How could it be, sir?
kindly turn to Order 21 Rule 103.
Yes, what does it say?
What I'm just reading it out for my satisfaction. Orders to be treated as degrees.
Treated as decree.
Where it
Treated as decree is different from decree under section 2(2). There is a distinction, sir. There is a distinction.
Well-
Have you seen, considered 1980 volume 1 CL, Mr. Rai, volume 1 CLJ? Volume 1 CLJ 161 or 141?
I think 161.
161.
But
It has been decided in 1980.
but since in that provision, my lord, I preferred a misappeal first, obtained stay. Now, since the misappeal was dismissed
Why misappeal was dismissed? On the ground of maintainability.
on the ground of maintenance. My lord,
Where is that order?
and not only that,
Where is that order?
that order is, my lord, at page 41.
41, my
Not only that, on the said day, when the appeal was dismissed, my client filed one application to convert the miscible into titleable. That has also not been considered. Whatever, my lord, my
What do you say?
client is suffering, my lord.
My lord, before, my lord, what point, my lord, my understanding is raising, my lord, before disposing of section 5 application, whether stake would be granted.
When the section 5 is fixed for hearing,
Section 5 is fixed for hearing, my lord, the next date, my lord, I have to take instruction.
please take instructions, come at 12. Please take instructions when the section 5 is pending.
Right.
Yes, call the next matter.
On my instance, my lord, this matter came up before your lordship. Your lordship passed an interim order holding that this scientific investigation, my lord, I say, my lord, myself and my wife has not executed the deed.
My lord, what I have been instructed that this matter was listed before your lordship on the mentioning of Mr. Mukherjee, my lord, that he will be conceding with this order.
Yes,
And my lord, this will be sent down to the court below for hearing.
Only
Right.
one thing, my lord, may I? Yes, my lord, your lordship has hold it premature since the evidence has not come.
Forgot what happened.
My lord, what happened, my lord? Here, myself and my wife alleged to have been executed a deed in favor of Mr. Roy's client. So, my lord, that deed is being challenged in my suit. They filed written statement and state why they have not prayed for local scientific investigation. They knew this has been executed by them. That's why cunningly they are
Scientific investigation with regard to comparison of the
signature
signatures.
or thumb impression. Because I have denied neither my signature nor my thumb impression. They insisted the court by filing written objection to the injunction application as well as in the written statement that very cunningly I myself being a plaintiff thrown a challenge to the deed but did not pray for scientific investigation. This is the pretext I applied for scientific investigation. That has been allowed. They came up before this honorable court stating that this is premature. Lord, I am just drawing your lordship's attention. Lord, my wife will not have died. I am also a senior citizen. 70. Lord, order 18, rule 16 is there, your lordship knows.
Evidence has not yet started.
No.
I want,
It has not come, so Mr.
so it's premature, Lord, I am conceding to that. But order 18, rule 16, your lordship knows, gives me that liberty so that, Lord, on their insistence, I can just produce that as a, Lord, preliminary evidence which is permitted under order 18.
Issues has also not been framed.
That to issue, even after.
Issues has also not been
Yes,
framed.
I know, my lord. Immediately after filing of the suit, this can be done. Your lordship kindly takes up order 18, rule 16 once.
When Mr. Mukherjee requires a hearing, I am asking it for
Conceding, my lord. Your lordship
What you are
allows the
conceding?
additional application.
conceding means the
My lord, impugned order needs to be set aside.
yes, I am
Because it's
setting aside that.
Lord, grants me that liberty so that, Lord, I can apply afresh. Lord,
You can take steps in accordance with
but,
law.
Lord, this your lordship's order will not preclude me to apply a
What order I have passed?
No. Your lordships, now your lordship is going to set aside, Lord, the order by virtue of which scientific investigation has been allowed.
Yes.
So, Lord, this will not preclude me in an appropriate stage to pray for scientific
Yes, yes,
investigation.
that has to be
That
done.
your lordship clarify. Lord, I shall take
That has
necessary.
to be done. Mr. Rai, cannot
No, no.
oppose that
No.
because your submission was
Yes. It is not at the appropriate stage on which this application has been allowed.
and I'm very much sorry,
Yes,
sir.
yes.
I'm very much sorry, my lord, because your lordship, I had the order that your lordship allowed the allowed the application for.
No. It is, I think, some corrections is correction key.
Yes.
Correction key. It's a correction. Indicate for
My lord, I am mentioning the order. My lord's order, lord, I mentioned this correction.
no. Did you mention it for correction?
My lord.
What is the correction
My
needed?
lord, at the time of passing order, I heard that the order your lordship allow this additional party. But unfortunately, copy the order is otherwise. But your lordship, the order is.
No. Inclined to. For that cannot be account for correction.
I'm not saying for correction. Your lordship can see only I'm submitting your lordship. The entire order passed by the trial court against the order have come your lordship regarding the additional party. But your lordship,
That cannot be account for. Though this matter was mentioned for correction,
My lord, you have to the opposite party, sir. If you hold the opposite party. Since on behalf of the petition appearing only today's accommodation, my lord. This is Shivangi Chakrabarti is appearing today. She has some difficulty, my lord. She requested me to wait for.
so Gupta is appearing. Where is Mr.
No,
Gupta?
my lord, he is the senior, my lord. Record, my lord. Kali see, my lord, the record.
Yes, what happened?
Well, today she has not come, my lord. Make it not today, my lord. Tomorrow she will come, my lord.
Not today, next. Yes.
My lord, extension of our interim order. No one is appearing for the opposite party. My lord can dispose it up. My application for local investigation has been rejected on the ground that it can be disposed of by evidentiary and oral evidence. But if my lord goes through the plain in
No,
paragraph,
I cannot take up the hearing of the civil division application in their absence. I'm extending the
no
interim.
one is appearing. I have checked. No.
Maybe, but this is the extension of interim order. I cannot take up this application. Can you have filed for extension of interim order?
Fine.
This is an yes. Yes.
This is my extension of interim order, my lord.
When it will expire?
My lord, it would expire on my lord, September. It was granted till end of September.
Yes. What is the impugned order, Mr. Halda?
I'm telling my lord, my father, my lord,
What is the impugned order?
impugned order is, my lord, this division is directed against an order by which my application for stay of the suit has been rejected, pending disposal of the, my lord, tenancy right before the learned controller. Admittedly, my father was the, my lord, tenancy in respect of the suit property. My father died.
Have you served upon the other side?
Yes. If you'll also kindly have a look at the, my lord, the order dated 17 January 2025.
Yes. Have you served upon the learned advocate who has appeared for the opposite party?
Now,
Yes. No. He has appeared in June 2024.
my lord, I over telephone, my lord, I intimated. Yesterday, my lord, over telephone, I
Serve a
intimated.
notice. Come tomorrow. The learned advocate.
On 9, my lord, I beg to appear for the plaintiff opposite party.
One of the plaintiff filed a suit for declaration of his tenancy right. My lord, in such a suit, my lord,
My lord, may I
I-
come back with necessary instructions? Kindly fixes a date. My lord, it was not appearing before your lordship.
The interim order is
I
Cannot-
don't,
Mr. Halder, that cannot be done. Yes,
the affidavit of service be kept with the report, my lord. Earlier, affidavit of service be kept with.
what affidavit of service? You have not served, which, this one? Affidavit of service taken on record. Yes,
Yes, my lord, item number 10.
yes.
My lord, interim order expired on June 30th June. I made
30th June of 2025.
25.
Why did you not mention?
Mentioned on 2nd July, my lord. But in the meantime, opposite party number 2 died. That is why, my lord, I make an application for substitution. So that I see, my lord, says interim order may be passed and
Cannot be done unless the substitution is affected.
that the substitution application is also your lordship mail. Substitution
Substitution is within time.
within time, my lord.
So move before the register, Lordship. The learned advocate, what is the number of can for
Can
substitution?
number 1.
Can 1 is for substitution.
Yes, my lord.
The petition is directed to serve a
My lord, interim order.
unless substitution, interim order cannot be extended. None appears for the petitioner at the time of call.
I'm appearing. I'm for the petitioner, my lord. It's that matter, my lord, where 2G, my lord, the original tenant died.
This is extension of interim order.
But if your lordship dispose it of, my lord,
This,
my lord,
this matter.
my
Why
lord,
2 matters?
my lord, two similar, 2 suits, that's why 2 matter. But only liberty may be
Same order.
given to mention, my lord, the matter, my lord.
That is there, Mr. Mukherjee.
There is my
Yes.
suit, my lord, for eviction, that is,
Yes, yes. All suits are for eviction. Most of the suits are for eviction, Mr. Mukherjee.
that's,
You are benefited in one matter.
my lord, we'll
Another
try our
matter.
luck, my lord, we shall, your lordship is taking up mentioning, my lord, we shall try. Great.
Item number 48,
14.
14, my lord, I beg to appear for the petitioner. My lord, by dint of the order impugned, my application for condonation of delay in preferring an appeal under section 21A, subsection 2 of the Consumer Protection Act has been turned down. My lord,
21A is what?
I tell you, lordship, state commission, original jurisdiction was applied, and my lord, my complaint case was dismissed. Against that, I prefer an appeal before the National Consumer Redressal Forum. My lord, there was a delay of 148 days. That delay application has been rejected. Against that, my lord, I have no other alternative other than to come before your lordship under Article 227.
Why appeal before the Honorable Supreme?
Yes, my lord, that decision, my lord, there is a recent decision of the Honorable Supreme Court where it has been said, and thereafter also Universal Sompo General. Your lordship would kindly takes paragraph 39. Relying on Irbat Faizan.
Yes. No, so this is, Mr. Banerjee, this is, you have the Consumer Protection Act.
Yes, yes, yes.
The appeal provision is 58, I think.
No, in this under the old act 1986.
Oh, this is under the old act.
Under the old act,
Yes.
the provision is the appeal is under section 23.
That is 21A1.
Yes.
21A1 is original complaint.
Before the National Consumer Forum. 21A2 is the appeal.
So against appeals, against an appellate order, there is no provision of 226 and 227 is the remedy.
And Article 136, my lord knows the judgment, my lord has discouraged the practice. You have to come before the jurisdiction.
And jurisdictional court, which will be the jurisdictional court of the National Commission? It's in Delhi.
But my lord would kindly take into consideration the original order that was passed before the State Commission of West Bengal, my lord. Kindly takes, my lord.
What is that decision?
My lord,
That has also been clarified.
that has also been clarified, and this order, my lord.
Where is that decision? You have not brought that.
Not brought that, my lord.
Because that question arose.
Yes,
because against an order of the National Commission,
Which
whether
will,
the Delhi High Court will have the jurisdiction
jurisdiction
or
or
the
this,
Calcutta High Court. It went from Calcutta itself.
my lord, pardon me, my lord, I did not bring this.
Ashwin. This,
But
of station, my lord. I am
on
praying
the
for
prayer of the learned advocate for the petitioner. Yes.
adjourn for a week, my lord.
Yes. Yes, Mr. Mahato.
My Dennis, I am the my plaintiff in a suit for declaration. I challenge the gift deed executed by the father. My lord, I filed an application for injunction.
You have challenged the gift deed executed by the father. Gift deed was in favor of your other brother.
My lord, I prayed for injunction. That injunction has not been granted, my lord, on the ground. My lord, whether I can challenge the deed, that has been discussed. I have no merit in the suit. It has been discussed, and my lord, my application has been rejected.
What is the injunction? You are in possession.
Well, it is after the death of the father.
Are you in possession, Mr. Mahato?
No, no.
Then
My lord,
what injunction can be?
co-sirer. My lord, I am co-sirer. He should not transfer. He should not transfer.
Where is the prayer? Where is
Transfer
the,
alienation.
where is
Change
the,
the nature and character.
where is your prayer for injunction?
My lord, injunction application is at page 10 and prayer is 14. Causing, so for possession, my lord, it may be. But so for the changing the nature and character and not to transfer, my lord, those should be alienating. Last 3 lines, 4 lines.
Alienation you have not prayed for, Mr. Mahathir.
Yes, I have checked it.
Show me.
Last 3
From
lines.
alienating.
Alienating a schedule should provide to any third party. These two from changing the nature and character and from transferring, alienating.
Where is your plaint?
Plaint, my lord, I have not annexed it.
You have not annexed the plaint?
No, I have
Mahathir.
not annexed the plaint, my lord. This.
You have a copy of the plaint?
Yes. This is one.
Mr. Mahato, how this suit is maintainable? How this suit is maintainable?
Suit ki ache? Yes. Why it is not? One of the daughter has filed the suit.
Yes. So in a joint property, only declaration would suffice.
Declaration of my lord, my share.
That will suffice.
Declaration of the deed give.
If you are entitled to, Mr. Mahato, if the gift deed is set aside,
Yeah.
what's the effect?
Effect, my lord, co-sharer.
Then declaration would suffice.
Declaration of the deed. Declaration to that way.
No. Declaration of your share also. Prayer A.
My lord, 1/4 share. My
That
lord,
would suffice.
my lord, the other 2 prayers are there.
Yes.
Declaration of deed. Deeds are not.
Yes, Mr. Mahato, if that is allowed, what is the effect? You have 1/4 share. Partition is not to be paid for.
My lord, kindly consider this. My lord, suppose it is a joint property. My lord, kindly consider.
Yes, joint property, yes.
I only declaration for 1/4 share I should not. But my lord, unless I pray for declaration, unless I have right, my lord, over there, I cannot pray for setting aside of the deed.
No, I'm not saying. I'm not saying.
My lord
for
says I should
cancellation.
pray for partition.
Yes.
I should pray for partition.
Yes.
But suppose, my lord, I am not praying. I am.
Suit is barred, Mr.
No, my lord, I have.
Show me with regard to your.
Only declaration is barred.
Show me your averment with regard to possession. What have you stated?
My lord, so far the possession of my possession.
Yes, you have paid for an order of injunction restraining them from disturbing your peaceful possession. So there is a disturbance with regard to possession.
The other 2
That's
prayers
the
are there.
basic in a joint property. Without partition, Mr. Mahato, suit is not maintained.
No, my lord, kindly consider this. My lord, if
And when the gift deed was executed,
one is 2016, one is 19.
and when the who executed, his father or
My
mother?
lord, I am checking.
Who executed, father or mother?
Father.
Father, when did he die?
My lord, he died in 21.
And suit filed in 22.
22.
Yes.
One is of 2016, another is on 2021.
The appellate courts, it was a contested one. In appellate court, it's ad interim or temporary?
No, my lord, I didn't. It is on contest.
No. Trial court was also on contest. Sir, Mr. Mahato. The
Possession, that's true, but my lord, this joint
So
property.
Mahato, it's
Possession,
difficult.
physical possession may not be, but my lord, it is, possession is always there, my lord, it cannot be, I cannot be housed by being a joint
Sir,
property.
Mr. Mahato, a registered deed is staring at your face.
Yes.
Unless that is
That
set
will be
aside.
that will be
So
decided.
unless that is so, unless that is set aside, you cannot take that benefit. Co-sharer, possession of one co-sharer.
That's true, that's true.
So
But in the meantime, if it is
that
transferred,
those principles which you are saying
if it is
can be
transferred, my lord,
can
if it is
be
sold out, my lord, it
applied
has been difficult.
in a simpliciter suit for partition. But when there is a deed and nothing to show that you are in possession, it's difficult. Yes.
But I am a married daughter, therefore it is, I am not in possession. But that does not mean, my lord.
It has been gifted to your brothers.
My lord,
It has been gifted to your brothers.
দিলে ক্ষতি নেই।
Yes,
The
but-
matters, my lord, between sister, brothers, relations are becoming. Because of this.
It's an ideal case which has to be sent to mediation, Mr. Ma. Yes.
17, my lord.
You are appearing? Yes. Yes.
The suit is for recovery of eviction, recovery of possession. My lord, I filed an application under order 26, rule 9, local investigation.
What is the suit for?
Suit for eviction.
Suit for eviction?
Recovery of possession, not under the premises. my lord.
No. If suit for eviction of?
My lord, my case is, I have got the property by virtue of a deed executed by the predecessor of the plaintiff.
You have got so you are claiming ownership.
Yes.
You are the
Those
defendant.
two plots are, my lord, adjacent. He is claiming that I am not in possession of the gifted property. I have encroached some portion of his,
Yes.
which are adjacent. My submission is before the trial court, my lord, that kindly engage an local investigation commissioner under order 26 rule 9, so that, my lord, he will demarcate the property, whether I am encroached his property or not. If I in my property, gifted property, then, my lord, he will not get the odd degree. But if I have encroached, then I shall release it. This is the application, my lord, before the trial court, which has been rejected.
Show me the plaint.
Page 8. Eviction of licensee.
Show me your written statement.
And page 13.
This is tag number is 457.
That number is 457.
Yes, show me your written statement.
Page 13.
Page 13.
1.
Show me your specific allegation with regard to this, where it is situated.
Now, page 15, paragraph 11.
Page 15, paragraph.
প্রকৃত বিষয় এই যে এই বিবাদী এই প্রকার বিবেদন করে যে প্রতিমা গড়ায় বাদীর স্ত্রী হইতেছেন এবং বিবাদী বাদীর ভাগ্নে হইতেছেন, বিবাদীর মাতা বাদীর সহোদরা দিদি হইতেছেন, বাদী
All are relatives, Mr. Mahato. Relatives.
Yes. And gift deed is there, I am positive.
Yes.
1994 সালে একখণ্ড দানপত্র দলিল মধ্যে দান করিলে এই বিবাদী কোন ক্রমে দানকৃত সম্পত্তিতে স্বয়ং এককভাবে ব্যবসা করিয়া জীবন ধারণ করার উদ্দেশ্যে কয়েকটি ব্যবসা যথা সার্ভিস ইহাতে বাদীর কোনরূপ কোনো অনুমতি প্রদান বিষয় ছিল না বা থাকিতে পারে নাই, ওই সমস্ত ব্যবসায় একক মালিক বিবাদী হইতেছেন। বিবাদীর ওই সমস্ত ব্যবসায় কোনো কালে নিযুক্ত ছিল না। বাদী ঠকাইবার জন্য অংশীদার সর্বে ব্যবসা করেছেন।
Where is the
And my lord,
where is the dispute raised, Mr. Mahato, with regard to this encroachment? Where is that dispute?
encroachment in the plain.
No, plaint there is no encroachment. Plaint is pure and simple eviction of a licensee. And you say you are not a licensee, you are the owner. Prove your title.
my lord, paragraph 11.
Yes.
বোলপুর অন্তর্গত
Paragraph 11 of
মৌজার সীমানায়
paragraph 11 of your
Plaint,
plaint.
plaint.
Yes. So paragraph 11 of plaint is অত্র আদালতের এলাকাধীন
মুলুক মৌজার সীমানায়
Yes.
গত ইংরেজি সদস্য থেকে শুরু করিয়া ক্রমশ অর্থনৈতিক কারণ উদ্ভূত হয়েছে সীমানায় মানে
No, there is no
property
boundary
that-
dispute, mister.
মানে
It does not say boundary dispute.
মানে,
Show me that you have raised the boundary dispute,
মানে,
that this is this plot, I am in this plot.
মানে, page 18 my application.
No, not the application, in the written statement, show me
Statement,
that you have made out a case.
My written statement paragraph 6.
Yes.
আরজির তপশিল বর্ণিত সম্পত্তির পরিচয় অতীব ভেগ ইনডেফিনিট এন্ড
These are denials, Mr. Mahato. Please show me your.
নট ডিনাই
Yes.
ওই প্রকার পরিচয়যুক্ত তপশিল সম্পত্তিতে বাদী কোনরূপ প্রতিকার পাইতে পারে না
Show me your positive case, Mr. Mahato.
This
Mr.
is-
Mahato, you are saying.
This is পরন্তু কাইন্ডলি
Yes.
পরন্তু অস্পষ্ট তপশিল যুক্ত সম্পত্তি সার্ভে পাস্ট অ্যাডভোকেট দ্বারা মাপজোপ করত আর সঠিক পরিচয় আদালতে রিপোর্ট সহ দাখিল না করিলে বাদী বর্তমান মোকদ্দমায় কোনো রকম প্রতিকার পাইতে পারে না
Yes.
মানে therefore মানে নালিশি সম্পত্তি বর্ণিত সম্পত্তি সত্যিও দখল সম্পত্তি মানে গৃহাদি সম্পত্তির অন্তর্ভুক্ত হয় অস্পষ্ট তপশিল সম্পত্তি বিনা মাপজোপে বাদী মানে দিস ইজ দি স্পেসিফিক কন্টেনশন ইন দি রিটেন স্টেটমেন্ট
Yes. Where is your positive case?
যে আরজির ওই দফায় নালিশি সম্পত্তি প্যারাগ্রাফ 7 লাস্ট টু লাইনস আরজির ওই দফায় নালিশি সম্পত্তি বোলপুর ফরিদপুর পাকা রাস্তার গায়ে অবস্থিত থাকা বলিয়া উল্লেখ করে তাহা মিথ্যা
Yes.
পজিটিভ কেস ম্যানার দ্যাট I specifically said that it is required to be these are my case that both the property are side by side, not only side by side,
Show me that statement side by side. So that's the case. Mr. Mahato, they have made out a case of eviction of a licensee. Your positive case is the plaintiff has gifted you.
Kindly come to page 12, schedule of the property. Page 12, schedule of the property.
Yes.
Plain.
Yes.
দক্ষিণে দানকৃত 5 শতক ভূমি ও তৎপুর বোলপুর সন্ধে পাকা রাস্তা আপনাকে দানকৃত
Yes.
It is on the southern side.
Yes.
Therefore, in the southern side, my gifted plan, I am
Yes.
using there.
Yes.
They are claiming this is my case that both the plots are both the lands are side by side. It is required to be demarcated by the commissioner, survey pass commissioner. From the plaint it appears from the schedule. উত্তরে আপনাকে দানকৃত 5 ডেসিমেল সম্পত্তি
Yes. Where is the, what is the impugned order? Show me.
Today is fixed for such and such. File petition such and such. Other side raise strong objection, no written objection. Upon hearing both sides, court formulates that the instant suit is for eviction of licensee, not a suit for encroachment, as such allowing the local investigation, delay the proceeding. Of the schedule, it appears.
Give me a minute. Mr. Mahato, what is your reply to the statements made in paragraph 6 and 8 of the plaint? Show me which paragraph you have dealt with. Paragraph 6 and 8.
6 and 8.
Yes, of the plaint. How have you dealt with those paragraphs in your written statement? After 5-9.
No, in paragraph 9, my lord, you'll find. Paragraph 9, my lord, you'll find. Page 14.
Yes.
Paragraph 9.
Yes.
আরজির 6 দফায় উল্লিখিত বিবরণ সহ বিবরণ সকল my lord has got it after 5 line. Paragraph 9.
আরজির
আরজির 6 দফায় উল্লিখিত বিবরণ
আরজির 7 দফায় where is 6?
my lord, it is 6th line, 9 paragraph 9, 6th line. আরজির 6 দফায় উল্লিখিত বিবরণ সকল বাদীকে প্রমাণ করে
Yes, yes. Vague denial. No positive statement with regard to paragraph 6 and 5.
And 8, my lord says 8.
Yes.
Line. আরজির 8 দফার উল্লিখিত বিষয় যথা বিবাদী তাহার মাতুল বিবাদী আসিয়া প্রকাশ পেয়ে যে মামা সাচেশন these are the dealings, my lord.
Yes, that is also denial. Mr. Mahato.
Specific case, my lord, I have stated in paragraph.
Mr. Mahato, the positive case in the plaint is they have admitted that in the gifted portion you have your telcor and other things not disputed.
Yes.
This is a room which the plaintiff claims that he is an advocate. He has constructed a room for the purpose of chamber. You have came.
Yes. My lord,
Ashu, this application
kindly consider unless it is demarcated, my lord.
necessary to demarcate.
applying for the petitioner filed a suit for declaration and recovery of possession and injunction against the erstwhile defendant number 3 and 4. Erstwhile 3 and 4 was trying to make an encroachment into my property. So I filed an application under Order 26 Rule 9 for local investigation. Before that would take place, the defendant removed the encroachment, and when it was conducted, it was normal and everything. Report was filed in the year March 2003. And after that, they did not contest the suit. Erstwhile defendant number 3 and 4. So ex parte decree was passed in November 2003, annexing the report as a part of the decree. Now, subsequently, this opposite party recalled the decree.
Opposite party means defendant number 3 and 4.
No. These at present opposite party of the revisional application.
Yes.
They purchased the property from the defendant number 3 and 4.
They purchased. They are the subsequent purchasers. Yes.
They purchased the property from 3 and 4 and recall the decree and filed the written statement, claiming no part of my property belongs to them. They denied the plan which I have submitted for recovery of possession and declaration. That is also wrong. And they also even prayed for local inspection be conducted. I accordingly again filed an application stating that they are also claiming that, but the court said earlier report was there, so further investigation carrying out will delay the proceedings, and there is no change of circumstances. Finally, even after that, I filed a 151 application, and that was also rejected. My lord shall come to the written statement.
Show me your application under for local investigation.
Yes, ma'am. That is a part. First one is annexure is 151. 151 application.
Page.
No, sir, I have filed a composite application, certified copy.
Oh, in the certified copy?
Yes. The first one is 151. That is after page 9. Oh, sorry, written statement. It is after page 25. There's 221 order is 151 orders. And along with, followed by that, there is an application and objection also. After which there is an application for original. That number is 217.
Where is the 151 application?
First one, after page 25. This after the order. 221 order number 221, 2 pages, then the application.
No, where is that? You have said that these structures were removed, thereafter again constructed. Where is that statement?
No, at that time when the report was original report 2003, when we filed, it was removed. So when it was,
where is that statement that it was removed, thereafter again constructed? Where is that statement?
No, after that, the decree was passed.
Yes.
But I have not made any statement. After this, when they filed, recall the decree and they filed the written statement. They even pleaded in the my lord, if your lordship comes to page number 11.
Yes.
Page number 11, paragraph 8.
Yes.
That's a written statement of the present opposite party.
Yes. No, no,
Say,
you told me that initially there was a construction which was removed. Thereafter, subsequently again construction. Where is that? If there is a construction which has not been removed, earlier report is there that will indicate that. So no further investigation is necessary. If you say yes, after that it was removed, again constructed, where is that statement of yours?
this has been constructed by the present opposite party.
Show me where have you
That is
stated
not
that?
there.
Then,
That is not there.
then that's not on record. Ashu, this application under যে সার্টিফাইড
19, my lord, I am for the petition.
Yes.
But the plaintiffs are the petitioners before your lordship.
What is the impugned order?
Yes, kindly come to page 158. An application for addition of party by one cooperative society that was allowed by the learned trial judge by the order impugned. And being agreed, my lord, we are before your lordship. The most interesting feature is this, that by the order
of June 2025.
Yes, yes. The learned trial judge will discuss the facts and provisions of law, but why the presence of is necessary, the cooperative, that has not been stated. Nowhere in the order impugned. After making discussions of the judgment cited by the parties, kindly come to only inner page 12 of the judgment, para 20. In the light of the above findings, it is clear that by arraying the petitioner, this court will decide the matter completely, effectively, and adequately. But why his presence is required, that has not been stated. Not a single line observation that yes, for this purpose.
Without without taking party, matter cannot be decided.
There is substance in the argument of Mr. Royal and advocate for the petitioner that the application for Yes.
Taking instruction. Next date is fixed on my lord, 2nd of September.
2nd of September.
Server copy, my lord.
All right, I'm directing this application to be taken up on. You have entered appearance.
No, my lord, since copy has not yet been served.
You serve a copy of the section 5 today.
In the revisional application.
In the revisional application, it is
That's been
annexed.
annexed. All right. So I'm done. So
21st
you
August.
enter appearance on the next date.
My-
2nd of
21st
September.
August is the date in the executing course. 21st August is the date in the executing.
Nothing will happen. This application under Article 227 of the
to the 21st August, only liberty to pay for adjournment on that day. particularly.
Already there.
Deposit of police cost. Deposit of police cost.
Don't proceed with that. Take steps.
My lord. Let the appeal.
The learned advocate, at this stage, the learned advocate appealing for the petitioner submits that next
Great.
disposed of. Toyota disposed of. Next. Yes.
20, my lord, I'm for the petitioner. So defendant is the petitioner before your lordship. My lord, application for local investigation has been allowed. Previously, there was an application that was allowed. And the learned engineer commissioner has already submitted his report in the year 2022. My lord,
Who are you? You are the
I'm the defendant, sole defendant. Defendant is the petitioner. And kindly see only one line. So
Order 6 Rule 17, you are not
no,
agreed.
no, I'm not agree. Because there is hardly any allegation against me. Allegation is as against the club. Kindly come to page 66, the amended portion. And how the commissioner can be appointed to find out whether the club is obstructing at all or not. So kindly see, this court thinks that for proper adjudication regarding disputes between the parties and local investigation.
Where is the application for local investigation?
My lord, at page 58. 53, my lord. I have annexed the earlier application also.
What is the suit for?
Suit for declaration that he is the
Please
absolute.
give me a
Page 9, my lord, the plaint.
where is the plaint?
Page 9. And the clear portion, no declaration, nothing. The suit is not maintainable. And according to them, I have already constructed iron gate. No prayer for mandatory injunction. Club is not a party. Allegation is against the club in the amended plaint. Permanent injunction from affixing the iron gate and or restraining them from committing any act of mischief in regard to the underground water, electric, telephone. His separate property. A report has been submitted already in the year 22. I have handed over the certificate copy of the engineer commissioner's report. And the same prayer.
Where is the amended amended plaint has been annexed?
I have annexed.
Show me that.
My lord, kindly come to page 63.
63.
63 and the running page 66 is the para 11A to be added. Kindly see, the allegation is not against me, not against the club. Mentioned in the schedule B herein above, which was used by the plaintiff and his family members for the free egress and ingress to and from the schedule left to be connecting road was blocked by the local Durga Puja committee by Young Star Club by constructing a big field Pakka Lord Shiva Bedi. Thus blocking the
Club is not a party.
No, club is not a party. Allegation is against the club. Club is not a party. Club has blocked the passage. Let him fight against the club. If required, making the club a party, if at all. And the learned court below is of the view that for adjudication regarding dispute,
If prima facie appears to this yes.
The defendant is the petitioner, to your lordship. That in a suit initiated immediately after service of summons, my lord, I filed an application under section 5 and 8 of the Arbitration and Conciliation Act, since there is admittedly the plaintiffs are the executant to the deed appended with the arbitration clause. That was filed on 10th of January 2025. The objection to section 5 and 8 was filed on 7th of February 2025. But kindly see, my lord, thereafter repeated adjournment, and my lord, the next date is fixed, my lord, on 7th of November.
What do you want?
If it can be disposed of, pleadings are complete prior to Puja vacation.
This application under article. Next.
Thank you, sir.
Huh? No, ওখানে থাক sometimes, এখানে হচ্ছে 7th of November. Yes.
I appear for the petitioner, my lord.
But I'm for the caveat of it.
The petitioner is a plaintiff in the court below, my lord. Suit for eviction on the ground of reasonable requirement. Suit was decreed in my favor. Thereafter,
requirement.
Yes.
Suit decreed.
Decreed. Thereafter,
what happened?
thereafter the defendant, opposite party filed an application under Order 21, Rule 1901 in the suit. In the same,
In the suit.
in that in execution proceeding.
Yes.
Thereafter, my lord, at the argument stage, they filed an application on Order 39, Rule 7 with 151 paying for repairing. Although, my lord, in the same property earlier, my lord, I have filed a suit wherein the defendants were carrying out the repairing works, my lord. we obtained a decree restraining in the making change of nature and character. Now, my lord, at this belated stage, that 39 Rule 7 was allowed, and thereafter repairing works order was passed, my lord.
You are the owner of the property.
I am the owner of the.
You will get a repaired shop room. What is the harm?
But kindly seize the decree, my lord. Which
They will not change the nature and character. That I will restrict them.
And kindly direct them the miss case. That is at argument stage. The miss case, the order 21, rule 1901.
The impugn order learned trial court specifically recorded that no adjournment shall be given in the miss case, and it will be disposed of expeditiously. The application for repair of the suit's room is allowed in expertise. The prince arbitration. However, the
repairing has been allowed. You effect the repairs.
However, the repairing was
how long it will take to effect repairs? I will see that prior to that the miscellaneous case is disposed of.
Oh, I don't know.
How long it will take to repair?
The stop room.
How long it will take to repair?
Another thing,
How do I know, my lord?
I'm asking.
Direct the miscellaneous case will be disposed of expeditiously.
Miscellaneous case is otherwise ready for hearing.
Yes. Another thing, they have also earlier filed a independent suit praying for declaration of tenant. That suit was also dismissed, my lord, on 31st.
There is the observation of this honorable court that you cannot sell in two boat at a time. You cannot file in 222(101) and a suit F. Earlier one application was allowed.
So considering the local inspection report, this repairing application was allowed. This application under Article 227 of the Constitution of India is at the instance of the decree holder.
My lord.
Is at the instance আগেরটা না treated as on desk list, মানে পরের যেটা অর্ডারটা দিল, ঠিক আছে, with the consent of the parties. Yes.
But in this matter, the plaintiff has approached before this court, Millard, as the trial court has rejected the application under Order 38, Rule 1, Millard. There are substantial amount due and payable, Millard. And order the arrears of the rent due, arrears of the rent was adjudicated in on under Section 7(2) of the West Bengal Premises Tenancy Act.
7(3) has been allowed.
7(3) has been allowed and the defense has been struck out, but substantial money, how can I recover that money from? How can I recover that money, Millard? That is
for you to advise.
Millard, I have filed an application for ensure the presence of the defendant. They are not, Millard.
That is a different thing.
My lord, kindly see where these owners will go.
Sir, you are challenging the order dated 11th of March.
Kindly see, my lord, this is the order, my lord. Last order.
2nd of April.
My lord, may I place this order, my lord, relevant portion. Keeping in the mind of the submission by the landed advocate of the plaintiff, it can be seen prima facie that the defendants were not complied with the order dated 7(2) application and accordingly their defense has been struck out. But the provisions of 38, 1 rule and 4 can be invoked only when there is a serious apprehension absconding of any of the party, and it is only then the aforesaid provisions can be applied for. Well, they are not coming, substantial 3 lakhs and rupees are due and pay. 3 lakhs 71,539 is due and payable, Millard, on the rent, on account of rent, Millard. You should consider, Millard, where this they have enjoyed the property more than 20 years, Millard, and without paying a single for the Millard. This is injustice, Millard, for the owners and landlords. Defense has been struck out, Millard. There should be, it will be evicted, Millard. But where is the substantial loss to the owners, Millard? Can you consider this aspect, Millard, Order 38, Rule 1 and 2? Thank you.
Application under Article 227 of the Yes, who is appearing? Next is also same.
Right.
For it, same order. Yes. Next.
My lord, very difficult to recover the rent, my lord, from it.
Be happy with the possession of the property. Yes,
But-
next.
But this is a short matter. What happened? If Lordship straight away come to page 321.
Right. No.
Actually, for convenience,
321.
I'm
What are you
sorry, I'm
praying?
sorry.
What is your prayer?
My prayer, my prayer is what happened. Matlab, an interim order was continuing since 19 November 2022. For several days, it is continued, and there is a talk of settlement also going on between the parties. One day, my lord, the clerk of the
Interim order be extended till the disposal of appeal.
and reimposed, my lord. It should be reimposed. Lordship, kindly allow me to correct that, my lord.
No, interim order in the appeal.
Yes.
So you have paid for extension of that. That has been rejected.
No, not rejected, my lord.
Then
one day, the clerk missed the date. No steps were taken, so interim order was not extended. If Lordship straight away comes to
which order?
321 পাতা দেখতে বলুন।
321.
321.
321 এ ইনফর্মাটা প্রথম দিল 19/11/22 তারপর সেটা এক্সটেন্ড হতে থাকলো।
Only I missed, Malad, the clerk missed the 321. This is 19th November. Submissions are recorded. Then
no, this is stay application is allowed on contest.
Lordship.
Interim order till next date.
Interim order till next date. Malad, this
Where does it say?
After ordered?
Yes, stay application is allowed on contest till next date.
Next date.
Considering the submissions, this court is the chance of settlement of the dispute through mediation. Then fixed 23rd for hearing of the appeal.
Lordship. So then parties approached. They have already advertised this land.
No, thereafter interim order was extended. Page
Yes,
323.
several days. Several days, Lordship.
When it should vacated?
On 29th at page 325.
29 January.
29th January, the learned clerk mixed the date, manner. So the interim order was not extended. Next date, on 3rd June,
জোসেফ খুঁজে পান আগে
at page 325. At 3rd June, we applied for extension and reimposition, my lord.
Extension, what happened? Copy served.
ওরা অবজেকশন দিয়েছে।
They want to file written objection, my lord.
That they are liberty to file.
Lordship, but
then what
in the
happens after that?
meantime is eviction from eviction order. I'll be evicted.
নেক্সট ডেট
What is the next date, please?
28 August.
28th of August.
28th of August is the next
Little
date.
delay on our
So
part.
I'm directing the that application to be decided on 28th of August.
In the meantime, some
Only
protection.
10
my
days. You are without any interim order from me.
Lordship.
Nothing
Some-
will happen
some-
for 10 days.
My lord, some protection, whatever way, Lordship, whatever.
10 days, nothing will happen. I am directing the
আরেকটা বলে দিচ্ছি, আমরা একটা সাপ্লিমেন্টারি দিয়েছি
মানে-
কারণ আমরা লিখেছিলাম এক্সটেনশন অফ ইন্টিরিম
মানে-
অর্ডার দ্যাট উইল বি রিইম্পোজিশন।
My lord, we have applied for extension by mistake. We have filed a supplementary that for reimposition. So Lordship, can we direct to consider the application for reimposition of the stay?
that you have said not an application. This is a supplementary affidavit,
Lordship.
not an application.
For
The application
correction,
is for
correction.
extension supplementary affidavit. Have you served the copy of the supplementary affidavit?
Supplementary affidavit, copy, sir.
সার্ভিস
Sir,
করে
put up filed also?
Who is appearing for port trust? Can you not serve them?
না বাকিল না ঠিকই বলছেন।
Yeah, we can serve.
জালান কোম্পানিতে অ্যাপিয়ার করে সার্ভিস
হ্যাঁ।
করে চলে আসে।
We can, না, এখন কইতেন।
এসকে জালান করে এখানে হয়ে যাবে।
ঠিক আছে। We can serve and come back, madam.
When?
Day after
tomorrow.
Day after tomorrow.
না ফ্রাইডে না স্যার, ফ্রাইডে থাকবো না।
আচ্ছা, তাহলে বল, তুই বল।
থার্সডে।
Thursday.
The
Had it not been eviction order, my lord, I would have not pressed so much. Because I have experience, interim order forgot to take steps, interim order vacated before next day. they
nothing
took
happened.
possession.
Nothing happened for more than 3 months.
Not
Stood vacated. Nothing happened for more than 3 months. So now it's only a matter of 9 days. I think Mr. Mukherjee is heavily putting pressure upon you. This Thing has been done for 8 months, and for 10 days it will be done. From January, it should vacated. Today you are on 19th of August, 28th of August is the date.
Unfortunately, there is talks of settlement going on. Representations have been made, meetings have been held.
It failed because of you, because you are not willing to pay the current rate.
No. For up to current paid.
It has to be, a fresh agreement has to be entered into as per the
We are paying
current.
No. As per current SOR, we are paying. We annex the copy.
Then why? What is the difficulty?
Time extended.
Difficulty is there in terms. They first thought it should go to central government for permission, approval. They sent to central government, said, no, you have to do it. It came back.
I'm appointing Mr. Trivedi as the mediator.
Yes, my lord. Yes. Here and now.
Mediation, it went to mediation, it failed.
No, it didn't went to mediation because the parties were settling. They have also made advertisement with first right of refusal to me. It's only their kata jomi. It's for 1.5 kata, port trust cannot let out anybody else.
First right of refusal, that means you are the
sitting occupant. I am the existing tenant.
So the original occupant left.
No.
Has to be first right. Beyond that, that's the notification of first right of refusal.
They say my lease has expired.
Yes. The lease of the original lessee expired.
I'm the original lessee.
Then you cannot be treated to be a sitting occupant, Mr. Shokar. That's difficult.
Whatever way they let out to me, I'm happy with that.
Notification.
Because it is a very small plot of land.
The occasion to deal with that in this division.
Of course.
Sitting occupant
Is a different meaning. Yes. Lordship. Sitting meaning occupant has a different connotation. Lordship is absolutely right.
Yes.
I cannot be treated as sitting occupant.
26, yes.
Early disposal can be moved by the senior.
বাজার খারাপ
My lord, I'm for the
yes.
My lord, I'm for the petitioner. My lord, I'm praying for admission of the civil revision. My lord,
for admission of the civil. What is the impugned order?
My lord, the impugned order, my lord, dated 28/4/2025. My lord, passed by my lord civil judge junior division Barakpur. My lord, in a my lord the succession case. My lord, totally, my lord, contrary to law. My lord, my deceased husband was, my lord, an employed in my lord rifle factory, my lord, in Ichapur, my lord, and my lord, he, my lord, dies in service, my lord.
Please give me a minute. Of July 2024.
My lord, it is in the page number, my lord. 28, my lord.
28.
My lord, the succession certificate application, my lord.
15th of July 2024 is the succession certificate application. 15th of July 2024.
Oh, my lord, page number 27. 15th of July. June.
Page 47.
My lord, is a reply, my lord,
Not the reply. Where is the application?
Application, my lord,
Dated 15th of July 2024. That was rejected. 15th of July filed by the opposite party was rejected. Where is that application?
my lord, that application has not, my lord, annexed, my lord.
That is the impugned application. Which has been, where is that?
My lord, that has not been annexed, my lord. Order is annexed, my lord.
You are the opposite party.
Yes, my lord, in the trial court.
You are the nominee.
Yes, my lord. And my lord, the second wife, my lord. Second wife, my lord. First wife, my lord, deceased. Second, my lord, please come to my lord. Page number 47, my lord. Is entire thing is there, my lord.
Where is the first wife? Is the opposite party number
Deceased.
2?
Yes, my lord. Is deceased, my lord. She is deceased. After
Opposite party number 2 deceased.
opposite party number 2, my lord, is the daughter of the first wife, my lord.
Opposite party number 1
One is the mother of the my lord deceased. My husband, my lord. Deceased
is the
husband.
mother of the.
Yes.
Yes. Yes, please serve. Petitioner is.
My lord, if my lord,
What?
interim stay till disposal of the revisional application, my lord.
What stay?
My lord, in the trial court, my lord, case is going on. My lord, next date is.
Case has to go on.
My lord,
Why?
my lord, since my lord, I am not getting pension also, my lord. My lord, please seize, my lord, page number.
No, this is not with regard to pension. This is only with regard to gratuity.
But my lord, they have stopped
not
my
the
lord,
subject.
pension, my lord.
Subject matter is not that. You are claiming that since you are the nominee, you have to be given the benefits, but you cannot deprive the other legal heirs. So nomination cannot supersede the ordinary law. So it's only the employer can get a valid discharge by paying to you. The other heirs are to be.
My lord, that is not.
Please serve upon the others. By the order impugned. Yes, sir. Will appear in the December monthly list as motion. December. Yes, next.
Milord, I am the plaintiff petitioner, Milord. Milord, the only ground on what I am challenging the impugned order, which is impugned before my lord, is that my application under section 151 for implementation of the order of injunction granted on contest was refused on the ground that I have my remedies under order 39 rule 2A, that is filing of contempt. My lord,
the order of injunction.
My lord will kindly come. My lord will kindly bear me for a moment. Order of injunction is at page 25, which has been made absolute. 25. My lord will kindly see the order at page 28. 28, my lord. Lordship will kindly bear me, my lord. I'm showing my lord.
No, this is 151.
My lord, not 151, my lord, before that, my lord. I apologize, my lord.
Where is
Lordship
that?
at page 25, my lord.
25 is
the order contested order, my lord. If my lord allows me to place it. This is the order, my lord, on contest.
Yes.
Now, my lord, after that,
That is your application under 151.
Lordship will kindly come to page. It starts at page 32. My lord, the relevant portion, my lord, is at page 36, paragraph 15. A report was filed before the learned trial judge that there is a particular curtain on the common passage which cannot be removed, and actually goods are being stacked behind that curtain and the order is not being implemented. That report was there before the learned trial court. I specifically stated that in paragraph 15 and 16, that for implementation, even the curtain needs to be removed, because my egress and ingress from the common passage where both of us are tenants, on a common passage, no curtain can be put. And that was a specific report of the police, which was filed before the learned court below.
The order of injunction does not relate to any removing of those curtains and other things.
My lord, if my lord kindly allows me to place once again, subject to whatever falls from my lord, if my lord kindly allows me.
Both of you are the tenants.
My lord, we are both tenants, my lord. My lord, will kindly page 25, my lord, if I may place. The defendant, their men and agents are hereby restricted from keeping goods on the common passage area of the first floor mentioned in the schedule, so that egress and ingress of the plaintiff would not cause obstruction and distress. So, my lord, there are two portions of the order.
By the order impugned, the application. None appears for the petitioner at the time of call, no accusation.
In this matter, Lord, last week I moved two matters where my lord passed an order dismissing those revisional applications. Handwriting expired. Handwriting expired.
Dismissing on merit or for default?
On merit, man. On merit.
So this is a similar order.
This will be a similar order, but those orders have not been available in the server yet, so I cannot produce a copy of the order.
Give me the numbers.
CO 2931. I'll write down it. Write it down.
What is this? Oh, this was in preemption.
Preemption case, deed, we sought for handwriting.
Relied on the Supreme Court decisions also.
Yes, my lord. I relied on one Supreme Court, one High Court decision.
Kalke rekhe din. This matter tomorrow under the heading orders kore din. The day after tomorrow kore din under the heading for orders. Yes, next. Yes, call the next matter.
But I am for the petitioner.
Yes.
The suit was filed where I am the defendant for specific performance of not a oral development agreement. It was their contention that there was a oral development agreement for the caveat.
Yes.
And Lord, it was their case, Lord, that they were trying to Lord specifically enforce a oral development agreement against Lord. They have stated one Mrs. LNOP is the owner of the properties.
Who is the owner of the property?
LNOP Private Limited.
Oh, private. All right. Yes.
Look, they have arraigned me without not stating in the plaint that whether I am the owner or not. My status has not been disclosed. But they are seeking Lord a degree against me only. Yes. The order 7 rule 11 has been taken out by my client that there is no cause of action disclosed in the plaint as against my client is concerned. But whom they admit to be the owner has not been arraigned as a party. I am the sole defendant. So I took out an application to say that there is no cause of action disclosed against my client and they have a clear right to sue against my client has not been disclosed. But that has been rejected by the learned judge by a non-speaking order. Your Lordship will kindly have a look at the order. Thereafter, I'll take your Lordship to the plaint and the application.
Yes, where is the plaint?
Lordship. Page 12, your Lordship. Now, Lord, kindly have a look into the cause title. Lord, I am the sole defendant.
Raja Uddog.
Raja Uddog. Now, Lord, their claim, Lord.
What is the allegation against you?
Lord, there's no specific allegation against me. I'll tell your Lordship, from 1 to 8, paragraph 1 to 8, Lord, they are saying that LNOP Products Private Limited purchased by several 5 deeds in respect of not this particular property. In the year
They are the owners.
They are the owners. That your Lordship will find up to paragraph 8.
Yes.
Then Lord, paragraph 9, they are not summarizing that the aforesaid 8 deeds said LNOP Products Private Limited has acquired every right, title, interest in respect of the aforesaid purchase
Then
property.
amalgamation.
Then amalgamation. Then Lord,
yes.
The construction. Second now, okay, to build up করতে দে. Then Lord, paragraph Lord 11, Lord, that they have constructed Lord on the several properties.
Construction also made.
Construction made. Then Lord, again LNOP comes. Then kindly come to paragraph 18. Nowhere your Lordship will find about not the name of the defendant. Paragraph 13 at page 18.
Yes.
That thereafter the said LNOP Products Private Limited and 2 other companies and 2 other companies.
TWO.
TO2. Even TWO2.
2 other companies.
With the view to amalgamate their companies and they then filed company petition number such and such with such and such in the original jurisdiction. Honorable Mr. Justice.
Amalgamation was made.
Amalgamation was made with whom Lord not stated. Not even Lord, the amalgamation order is Lord part of Lord the plaint.
All right.
Then Lord, that the developer has represented. They jump to who is the developer? That the developer has infrastructure and financial ability to develop the Schedule A property and has approached the owner to appoint the developer for developing the said property. Then
no, it has not been stated prior to that who is the developer.
No. Your Lordship will see in paragraph 15, Lord, your Lordship will kindly read another paragraph.
Yes.
Paragraph 15. That in order to facilitate the smooth development of the said property and of the project to be developed and built thereat and marketing the project, the owner, that is the defendant, has agreed to appoint the developer to carry out on behalf of the defendant. Here he says that he is the developer, that is the plaintiff. The development and marketing of the project, the sale of the sellable space in the project comprising in the units, parking space, commercial spaces and other constructed or developed areas or spaces there till completion of sale and or transfer of all such sellable spaces in the project and the developer, that is the plaintiff, has agreed to accept such appointment and to implement the project on the terms and conditions as contained hereinafter by an oral agreement dated 24 January 2022 with an understanding that soon thereafter the parties to this suit will enter into a development agreement on the same terms and conditions with a right to introduce any terms and conditions as may be required to facilitate the work of construction.
So oral agreement to be followed by written agreement.
Oral agreement to be followed by a written agreement and not the price promised is 10 crores. So,
that's the consideration for the oral agreement.
That is the consideration for the oral agreement.
To be followed by a written one.
But they say that there was a oral agreement to enter into a development agreement in writing.
Yes. And the consideration was also fixed.
Subject to payment of 10 crores.
So consideration was also fixed.
Lordship.
Yes.
Then Lord, nowhere your Lordship will find that Lord, that how they say that my client is the owner of the property. Because they are not directing Lord their relief against my client for such performance.
In this paragraph it says that you are the owner.
No, Lord, it doesn't say that I am the owner in that case.
The owner, that is the defendant.
But
paragraph 15.
Lord, that is at paragraph 15 that they say, but Lord, the previous paragraph, Lord, all that they have said is LNOP has how acquired.
Yes.
They do not say that how my client has acquired, my lord, the right title interest.
Maybe.
This is a
but
speculative suit. Why I say this? First of all, my lord, this is a huge property. They have filed the suit based upon, my lord, an oral, my lord, an agreement for alleging, my lord, that 10 crores is, my lord, the consideration without paying a single paisa to my client. Now, my lord, when I take out an application, now, my lord, they do not even in their written objection say that how, my lord, they attribute ownership to my client, because that was fundamental.
But Mr. Mukherjee, even if they said in the written objection to your application, that could not have been taken into consideration.
I understand.
Because it's only the amendments made in the
I
plain
understand that.
that is to be considered.
Then, my lord, Order 7, Rule 14 mandates, my lord, that they have to file, my lord, those documents which they rely upon in support of the plain. Now, my lord, this is
I think
absolutely a
Order 7
vexatious-
Rule 11 also has been amended to incorporate those also.
That is also a ground taken.
But Mr. Mukherjee, those are curable defects.
But I will rely on a judgment, my lord, to say that your lordship, my lord, if your lordship doesn't find any, my lord, a cause of action disclosed against my client, my lord, it is a vexatious litigation.
Cause
So, my
of
lord, that has to
action,
be, my lord, nipped
you
at the
may
bud.
say not that elaborately, but Mr. Mukherjee, the thing is that
May I just
there's a distinction between pleadings and the evidence. You need not
I understand.
plead evidence
I understand,
in
my lord,
the
that.
pleadings.
But not for the evidence to be led, not the basis has to be not made in the pleadings itself.
Says says that you are the owner.
But how that merely branding somebody as a owner, it doesn't make it to be a owner. But he has to elaborate how I have become the owner. Nowhere, not in the plaint, your lordship will find. No attempt has been made from 2022 to elaborate. Even I took out an application to say that you did not disclose any cause of action against my client.
That
Lord,
can
when
be
I
a very
took an
that
application,
can be a good ground for dismissal of the suit. That can be a good ground for dismissal of the suit.
Question to myself, Lord, is that, Lord, why should I be, Lord, subjected to, Lord, a arduous suit, Lord, when there is no cause of action pleaded against my client?
Some cause of action has been pleaded. Maybe
But merely
that
my
all
saying that,
became
Lord, I
known.
am an owner. If
Yes.
Lord, kindly see, there only not the statement, how it comes, Lord, and jumps from that, Lord, paragraph
This is
13.
paragraph 15.
Paragraph 13. Paragraph 13 is, Lord, that
Paragraph 13 is the amalgamation.
Amalgamate their company with other companies. So amalgamation means, Lord, LNOP plus, Lord, the other companies.
Yes.
Or it might amalgamate into one company.
That's the merger.
That's a merger.
So if others are brought in with regard to a larger, that's a merger. Amalgamation means two or more companies amalgamate to form a new company.
That is, and in a sense, Lord, it might also, Lord, turn out to be a merger, Lord.
Yes. Yes.
But by merger, how, Lord, the sole defendant became the owner is, Lord, not explicit in the plaint to give, Lord, a cause of action against my client. Jumps to, Lord, paragraph 15 to say that, Lord, he is the owner. I talked with him about a development agreement, and there was a talk about written agreement on the promise of 10 crores to be paid. And, Lord, the suit has been filed, and, Lord, they are trying for, Lord, an interim relief in this. Why I say it is speculative is, Lord, how they frame a suit and whether your lordship will allow, Lord, this suit, Lord, which is absolutely, Lord, a vexatious one.
This Order 7, Rule 14,
Lordship.
Mr. Mukherjee, non-filing of those documents is not a ground for rejection. I was under the impression two new grounds has been incorporated. That is where it is not filed in duplicate and where the plaintiff fails to comply with the provisions of Rule 9. Rule 9 is with regard to summons be served on the defendant, it will direct the plaintiff. So Order 7, Rule 14, yes, those documents are to be.
The documents which form the basis of the plaint, Lord, are to be appended as a list of documents under the amended provision.
But Order 7, Rule 14(3) makes it clear, if that is not done, that cannot be produced without the leave of the court. That cannot be a ground for rejection of the plaint.
Why I say that, Lord, they say that there has been an amalgamation. In support of that, they are supposed to, Lord, rely upon the documents under Order 7, Rule 14.
That has not been produced. If that was produced, call upon them to produce that document. Those provisions are there.
I am
Those
not
provisions-
supposed to make a case for themselves. They are seeking a relief against my client. And as your lordship sees, from the averment in the plaint itself, they do not make out any case against my client. That how they attribute the ownership, but merely by branding somebody as an owner doesn't make it an owner. They have to give something in the plaint to say that how the ownership have devolved. All about LNOP, all about 2000. Then they suddenly come and say, that there has been an amalgamation. The amalgamation order was also of the year 2009. Then they jump up to in 2022 at paragraph 15 to say that I as the owner have agreed. Kindly see the third line at paragraph 50.
So their suit is because the follow-up written agreement did not come through.
The follow-up written agreement did not come through.
That's their relief in the plain, though there was a formal agreement for development.
That is. But my contention is that if you want to enforce this particular development agreement, it is enforceable only against the owner. And you do not write down in your plaint that how the ownership have devolved. So the fundamentals of the plaint for seeing the relief, that is lacking. That is lacking.
Some cause of action has been disclosed, may not be in that so many words by saying that how you became, because but they
think your lordship will kindly see
may not be, Mr. Mukherjee, the plaint may not have been happily drafted because how? Because initially it was LNOP who was the owner. Paragraph 13 makes out a case of amalgamation, and the order of a court is also
amalgamation with which of the companies are not also spelled.
Two other companies, you are right. So which two companies, that is not specified, but the orders, yes, you are right.
Order 7, Rule 14 not resorted to by incorporating that order to say that the defendant is the company with whom it has been amalgamated. Nothing is there. Jumps to paragraph 14. 14 has got nothing to do. Then in paragraph 15, it only says and market the owner. Third line, that is the defendant has agreed to appoint the developer. And that is the only sentence that is that they have.
14 says that the developer has
The developer is the plaintiff. Developer
the owner approach to the owner to appoint him as a developer, and 15 says the defendant is the owner.
Right. And who is the owner? Nothing has been spelled out.
Defendant, it has been said.
So,
defendant means you.
That is in paragraph 15. He says that defendant is the owner.
How you become the owner? The devolution of title, Mr. Mukherjee,
That is not what
is
the
it
judgment.
necessary? That can be proved.
Foundation of the evidence are to be laid out in the pleadings. That is well settled.
That's the distinction.
Merely by saying that somebody is the owner of Victoria doesn't make it out.
Thing is that you need not plead the evidence. So if you say, so what's the necessity? If you say yes, start tracing out your title from 1910, how it become, is it necessary? Or you can say, I became the owner by virtue of this deed. Now you can say, yes, in the evidence you can trace out the back deeds and the chain deeds. It's not necessary for you to trace out your title from 1910. So,
but it is for the
plaintiff. The evidence did not be so. You can also say, yes, I have become the owner by virtue. In the evidence, you can prove how you became the owner.
But it is not my duty. It is for the plaintiff.
Evidence without pleading is you have not pleaded. If you have not said you are not the owner, but you are producing the documents, that's evidence without pleading. But it's a general rule, Mr. Mukherjee, you must have seen the olden, those planes.
Yes.
Half page, one page. Now,
and everything is stated.
Yes.
Everything is stated.
You will not find a single evidence pleaded in the plane. That's the way it's drafted. So it's only proceeds that I am the owner by virtue of such and such and such and such. Now you trace out your title from 1910. This entire recitals set out, extracted in the plane, all deeds annexed. Then you paragraph 37. Yes, by virtue of this deed, I become the owner. So those are not necessary. So now it's the owner they have stated. They have also stated the case of amalgamation, you are right that particulars in view of the recent amendments, Order 7, Rule 14, those are necessary.
In that event, Lord, about the maintainability, Lord, there should be a preliminary issue, Lord, because
Maintainability has to be that has to be.
Because, Lord, why relegate myself to a suit, Lord, long drawn, when, Lord, it can be seen from the framing of the plaint that it cannot be sustained.
You have filed your written statement, no?
Written statement file করেছো? File করে দিয়েছো? Yes.
So if the written statement is filed, maintainability will be an issue. I think we have also
That
raised
can
that
be as a preliminary issue, Lord, because because it's a mixed question of fact and law.
mixed question of fact and law cannot be decided as a only if it is a question of law. Order 14, Rule 2, Sub Rule 2, Mr. Mukherjee, if it is only a question of.
Lord, I understand that.
So preliminary issue will be
I
a
understand
difficult
that.
thing.
Then, Lord, your Lordship will
I can direct framing of the issue with regard to the maintainability.
But I will, Lord, just rely upon, Lord, one judgment, Lord, which it is reported in 2020, volume 16 Supreme Court cases, 594, Lord, a vexatious plaint, Lord. That is well settled from Lord,
77.
77.
Yes.
And thereafter, Lord, but I have to, Lord, fit that into the facts of my case, Lord. The propositions are well clear.
Yes, yes. Which paragraph you are trying to rely upon?
Lord, Lord, about, Lord, paragraphs, Lord. Yes, paragraph 5.
5.
Yes. And then, Lord, kindly come to paragraph 7. Then paragraph 8.
So Mukherjee, this is on Order 7, Rule 11.
Yes, Lord, this is on. Kindly.
Memorandum of partition placed on record.
Lord, your Lordship is, Lord, 2020, volume 16 Supreme Court cases.
Yes.
Then, Lord, your Lordship
please see paragraph 6. Memorandum of partition which was placed on record.
But this was in the context of, Lord, that there was no, Lord, right of preemption, Lord, ordained by a particular.
That I follow. But memorandum was produced at what stage? It says paragraph 6, which is placed on record, and an accepted admitted document does not give any right to the first defendant. Those documents produced at what stage?
Lord, this was, Lord, at the stage, Lord, but after, Lord, the hearing. The partition was evidenced by recording memorandum of partition, paragraph 3, which was signed and executed by the three brothers. Paragraph 3.
Yes. The partition was evidenced by recording memorandum. Factum of partition.
The factum of partition and the partition deed itself
not
is
challenged.
not challenged and questioned in the civil suit preferred by the first respondent. In fact, Sunil Kumar Mehta, the third brother, is not even a party to the suit. The suit also acknowledges the second
that is the
respondent.
very basis, because it proceeds on the basis of an admitted document.
So it say that, Lord, in the plaint you have to, Lord, disclose the clear right to sue. That is, you are asking for certain relief, but you do not plead in the plaint about the basis that how you are supposed to get that relief. This is not the ratio of this judgment.
Yes.
Which, Lord, I say in the context of my case also, Lord, that they have not elaborately laid down that.
How you became the owner, that has not been.
So as to, Lord, maintain, Lord, a relief against my client against in the nature.
Your case is that there is no correlation between paragraphs 13 to 15.
Secondly, my Lord, whether I am the owner or not, that has
yes,
been,
because if there is no correlation. 13 to 15, if that is correlated, then ownership comes, because it says amalgamation between two companies, and then they jump to the conclusion that you have become the owner. So there's a missing link between these two paragraphs.
Lordship. Yes, and Lord, they have not even taken any steps, Lord, for correction in spite of my, Lord, taking out a specific application.
Yes, what do you say?
As per
how much time we will take? Come at 2? So Mukherjee will be available at 2. Lordship, come at 2. How much time it will take? Have you noted this decision? Have you considered this? Or you can take this, you can.
I can hand over. I have got a soft copy. Or I can give a photocopy and retain one for your lordship.
Consider after that.
এটা একটা photocopy করে দিতে। না, এটাই আচ্ছা তুই আর প্রিন্ট করবি।
আর দুটোর সময় ফিক্স নেই তো
নোট নিতে পারিস
না
তুই পড়ে নিয়েছিস তো ঠিক আছে, আমি তোকে এ করে দিচ্ছি।
yes
এখানে আছে আমার কাছে
yes
My lord, in paragraph number 13 of my plaint, it is accepted that there is a amalgamation, my lord,
with whom
with the present defendant, my lord. It is,
where is that
there,
show me where is that
there is a regarding that I can cure the defect, my lord. But kindly consider one thing, my lord.
cure the
They-
defect till now it's not cured defect remains
No, no, my lord. After
I cannot consider the plaint
but
what
my lord,
we
kindly
do after
consider
this.
one thing, my lord. The defendant never denied that they are not the owner of the property, my lord, and they never denied that, they are not the.
This is not this stage. This is the stage prior to their filing of the written statement.
In the written statement, also,
You have to succeed on your own plaint, sir. You cannot bank upon his weaknesses. So it's order 7, rule 11 only has to be considered on the statements made by your plaint.
In paragraph 15.
Even if he says something in the defense that cannot be looked into.
In
That cannot be
paragraph
looked
number
into.
15, my lord, that in paragraph number 15, my lord,
Yes, 15 what you have said.
that the owner, that is the defendant. That means after amalgamation, the new
What
company.
is the link between the previous paragraph with paragraph 15? Where is the connecting link? How do you link paragraph 15 with the previous paragraphs?
There is a small defect, my lord, but at the stage of, at the time of, during the course of evidence, my lord, it will be crystal clear, my lord. In any point of time, my lord, I can cure this defect, my lord. They never denied it.
This application
It's my application. Plaintiff petitioner before your lordship suit for eviction of licensing. Now, my lord, during pendency of the suit, defendant suit since I am opposing that. Now, my lord, the defendant come up with an application under section 10 of the Code of Civil Procedure, praying for the stay of the present suit for eviction of license. That was initially rejected by the learned court below. My lord, file, my lord, is page 45 and 46. Subsequently, my lord, another application under section.
Your suit is for eviction of a licensee.
Subsequently, my lord, another application under section 151 of the Code of Civil Procedure has been preferred by the defendant following the same principle of section 10, which was allowed the suit by state. But against that order, my lord, my humble submission.
What are the stages of both the suits? What is the stage of your suit for eviction of a licensee?
For eviction issue yet to be filed.
And in the probate suit?
Probate suit, just my lord, I appear and it was turned to the my lord probate suit, and my lord, WS yet to be filed. Okay.
What?
Who is different? There is a case for a bad lord is paragraph. One suit is for the regarding the claiming of a share, another suit by virtue of a deed of gift, one are claiming of the entertainment and eviction of license. Your lordship was held that both the issues are different, so section 10 is. Here is a sentence. Critical point is not been dealt with by the London court because since section 10 has been rejected earlier, self-same application.
Where is your plaint?
My lord. My plaint is, my lord, page 24. My lord, sorry. Page 21 starts, my lord. Ends with page 24. The defendant did not challenge the registered deed of gift, by virtue of which I am the owner.
No, probate is the will of whom?
Will of our deceased mother, who executed a deed of gift in my favor, that is page 12, my lord. It was executed on 9/6/2009.
No, in the plaint you have stated
yes
that you have got this property by virtue of a deed of gift.
Yes. That deed of gift has not been challenged by the defendant.
No. So what is the relation with the probate suit then?
Probate suit is, my lord, my another brother against whom I am praying for a eviction of licensee, my lord. He alleged that by a notarized will in the sometime in 8/7/2008, will was executed in his favor. So he made an application for probate, where my lord, after giving notice, I appeared therein, which became turned to the probate.
In this suit, they have entered appearance.
We have entered appearance.
Not in the probate suit, this eviction
Yes,
of a
yes,
license.
yes, page 26, they are
What
written.
is their written statement with
Yes,
regard
page
to the
26.
registered deed?
Page 26. 26, 27, and 28. They have not challenged even the one of the deed of gift. And their application section was. No, I am suffering, my lord.
Yes, call the next matter.
On this application on, my lord. A copy.
One, yes.
I am for the petitioner.
Yes.
But the defendant number 8 to 22 is the petitioner before your lordship. 8 to 22.
8 to 22.
Yes. Well, it's the petitioner before your lordship. Now it's challenging an order, well, by virtue of which it's a second round of Order 6 Rule 17 is being allowed by the learned trial judge. But if your lordship takes up the plaint, Lord, I have annexed the amended plaint. Lord, I will not trouble your lordship. Your lordship kindly takes up plaint starts with page 17. Kindly takes up page 26, paragraph 5. Is the positive statement that from Lord, paragraph 5, Muslim alias Mochlem and Milord Osman alias Ochman, from which Milord ultimately the bearers have purchased. Your lordship got it, Milord?
Yes.
So, and the remaining property of certain decimal was within the Milord Osman alias Ochman, who is the first Milord plaintiff. And Milord, we do not have any right title interest in respect of the cost schedule property as mentioned in the plaint.
Yes.
Kindly takes up now, Milord, the prayer. Page 33. So he claims, Milord, he is the owner in respect of the co and cost schedule property along with the other co-sharers. And I don't have any right title interest. So, Milord, the permanent injunction. Milord, page 37, my written statement come counter claim. Again, Milord, I will not trouble. Milord, kindly takes up directly paragraph 21 at page 43.
Yes.
Kindly takes up Milord 6 decimal নালিশি 6 দাগ মুসলিম গং অর্থাৎ মুসলিম ও ওসমানের such and such সম্পত্তি ছিল দিস আপ টু মিলর দিস ইজ মুসলিম ও ওসমান একত্রে তাহা গত ইংরেজি such and such তারিখের বিক্রয় কবলা মূলে হীরেন্দ্রনাথ রায়কে 14 ডেসিমাল স্থান বিক্রয় করিয়াছেন হীরেন্দ্র অন্তে তাহার পুত্র অশোক তাহার খাদেমে ইংরেজি such and such নম্বর বিক্রয় কবলা দলিল মূলে হস্তান্তর করিয়াছি। Milord, the previous Milord acquisition of title is not being Milord challenged up to Osman, and I am claiming Milord a transfer made by these 2 persons to Hirendra and thereafter in favor of the present defendant. So I claim Milord right title interest in respect of this previous amendment. Milord, I am not troubling. Kindly now takes up page 49 the amendment. It's a longish amendment. Page 50 the Topshil Milord start schedule of amendment. Initially, Milord, it will apparent that certain portion is being very innocuous, but the main trouble started, my lord, at page 54. Now it's a continuation of paragraph 8 core that they want to insert in the plaint. Now, page 53 it starts. Your lordship got it? Kindly turns over the page, my lord. But may I?
Yes, yes.
May I place not from the previous page itself, otherwise the continuation was. গত ইংরাজি 54 থেকে 57 সালে জরিপের সময় 1 নম্বর বাদী নাবালক থাকায় এবং 1 নম্বর বাদীর জ্যৈষ্ঠ ভ্রাতা শেখ মুসলিম সদ্য সাবালক হওয়া বিষয়ে অনভিজ্ঞ ও মাতা সাচানসাচ বিষয় অনভিজ্ঞতা পর্দানসীন গ্রাম্য মহিলা থাকায় 1 নম্বর বাদীর মামা ও চাঁদনী বিবির সহোদর ভ্রাতা শেখ দবির উক্ত জরিপের কার্য 1 নম্বর বাদী ও শেখ মুসলিম ও চাঁদনী বিবির পক্ষে দেখাশোনা করিয়াছিল। 1 নম্বর বাদী শেখ মুসলিম ও চাঁদনী বিবি উক্ত শেখ দবিরের অতীব বিশ্বাস ও ভরসা করিত এবং সেই বিশ্বাস ভরসার সুযোগ লইয়া শেখ দবির নালিশি দাগগুলির বিন্দুমাত্র সত্য দখল না থাকা সত্ত্বেও নিজ নামে জ্যৈষ্ঠ ভ্রাতা মৃত সাচানসাচ পুত্রদ্বয়ের নামে কয়েক সম্পত্তি রেকর্ড করিয়া লইছে। 1 নম্বর বাদী শেখ মুসলিম ও চাঁদনী বিবি কিংবা পূর্বাধিকারী মকবুল কখনো সাচানসাচ দাগের কোনো ভূমি উক্ত শেখ দবির মৃত জসিম কিংবা তাহার পুত্রদ্বয় ইসমাইল ও খাদেমকে হস্তান্তর করে নাই। নালিশি দাগগুলি ইংরেজি সাচানসাচ জরিপের রেকর্ড ভ্রমাত্মক প্রকৃত দখল সত্ত্বের বিপরীত হইতেছে। গত ইংরেজি 54-57 সালের জরিপের রেকর্ডের ভিত্তিতে পশ্চিমবঙ্গ ভূমি সংস্কার আইনের সাচানসাচ প্রস্তুত হয়েছিল। দ্যাট ইজ অলসো মিলট ডিনাইড। কাইন্ডলি মিলট টার্নস ওভার দি পেজ। অংশমন দলিলটি শেখ দবিবের তত্ত্বাবধানে ব্যবস্থাপনায় হয়েছিল। পিতৃত্যাক্ত সম্পত্তি শেখ দবিবের ভগ্নীদ্বয় আমিনী বিবি ও চাঁদনী বিবি একত্রে 1/3 অংশ প্রাপ্ত হইয়াছিল এবং উক্ত 1/3 অংশ সম্পত্তি নিজ পুত্র সাচানসাচ জ্যেষ্ঠ ভ্রাতার পুত্রদ্বয়কে শেখ ইসমাইল ও শেখ খাদেমের নামে দানপত্র দলিল করাইয়া লইয়া গিয়া চাঁদনী বিবি ও কামিন বিবির অজ্ঞাতে তাদের কিছু জানিতে ও বুঝিতে না দিয়া গত ইংরাজি 10/1/1955 তারিখে সম্পাদিত রেজিস্ট্রিকৃত সাচানসাচ দানপত্র দলিলে নালিশি দাগের সাচানসাচ কতক সম্পত্তি অন্তর্ভুক্ত করিয়া লইয়াছে। উক্ত অন্তর্ভুক্ত সম্পূর্ণ বেআইনি হইতেছে। চাঁদনী বিবি ও চন্নী বিবি ও কমিনী বিবি পিতৃত্যাক্ত সম্পত্তির দলিল করিবে দলিলে উল্লেখ রহিয়াছে, কিন্তু নালিশি সাচানসাচ দাগের সম্পত্তি তাহাদের পিতৃত্যাক্ত সম্পত্তি ছিল না। চাঁদনী বিবি নিজ গর্ভজাত সন্তানকে বঞ্চিত করায় ভ্রাতৃপুত্রদের বরাবর স্বামীত্যাক্ত সম্পত্তির দলিল মূলে কিংবা মৌখিকভাবে দান করিবে মনস্থ করেন নাই এবং বাস্তবে কার্যকারিত হয় নাই। So, this is something the derivative title from 1955 deed, they have tried to be challenged by virtue of this amendment, and will not kindly takes up now how this amendment
was at what stage?
This not trial commenced, but not kindly see how this has been dealt with. The learned trial judge has said, I have taken a specific point of limitation in my written objection. The learned trial judge says nature and character of the suit will not be changed.
It prima facie appears to this court affidavit of service, why?
In this matter, my lord,
এটা কোনটার affidavit of service?
Lordship, I appear on behalf of the plaintiff petitioner. Lordship, the plaintiff had filed a suit for eviction. Lordship, what has happened is that the original plaintiff has passed away and thereafter her husband and daughter had been substituted. After the substitution, the husband also passed away, so only the daughter remains a legal heir. So the leave was granted to file an amended plaint to the daughter. However, what had happened is that we had filed an amendment plaint. So what the plaintiff did in the original plaint was that the plaintiff had annexed the documents. There was no separate tableau statement mentioning the list of documents because the documents itself was annexed with the original plaint. I have annexed the original plaint. Now in the amended plaint, the documents were not separately annexed. But by way of abundant caution, a section 151 application was also filed to annex those, to treat those documents also as a part of the amended plaint. So, Lordship, we have come before Lordship against the order dated 21st January 2025. My 151 application has been dismissed with cause, my lord. But Lordship, the original plaint contained the documents.
Only the cost title was amended.
Lordship, only the cost title was amended, but perhaps because the original plaint contained the documents as an annexure instead of a list of documents like we generally do. So, Lordship, the advocate in the lower court had not annexed it with the amended plaint. Thereafter, when he realized he had to be annexed, he filed a 151 application. Lordship, there was a bona fide mistake on our part. There was no mischief under Order 7, Rule 14 has been transferred in the order.
Where is the original plaint?
Yes, Lordship. The original plaint starts at page 41, my lord.
Page?
41.
41.
Lordship will see the annexures as annexed with the plaint as we do in a petition.
Yes, but there is no separate list of documents.
There's no separate list of documents, but Lordship will take page 52 onwards. Annexure A is present. Thereafter.
Right. Where is the application under section 151?
Yes, Lordship. 151 is page 30, Lordship. And the price at 31.
There's a page?
31.
Yes.
Petition in this matter.
What is the impugned order?
The 28th February 2020, passed by the District Judge Nodia.
February 2020.
My lord, we wrongly filed an appeal before the Honorable High Court, my lord. We asked to withdraw the same, and another, my lord.
Where is that order of withdrawal?
It's annexed to P7, my lord.
Page.
My lord, page 79, my lord.
Seventh of March 2024, and you have filed it in August 2025.
My lord, we had applied for the certified copy, my lord. There was a procedural delay, and we after.
What certified copy? How long it takes to obtain the certified copy? Server copy is there. Server copy is there. And you have annexed the server copy, not the certified copy. What prevented you from filing this application earlier? Yes, what is the order you are challenging?
You know, the order passed by the revisional court, my lord. You know, the Civil Judge Junior Division Nobodip had set aside the suit, had dismissed the suit on the ground of it being barred by Section 85 of the Wakaf Act 1995, and this and that particular order was reversed by the revisional court as a District Judge Nodia, my lord.
Yes.
Not as per Section 85 of the Wakaf Act 1985, my lord, when there is a tribunal to decide the dispute, the civil courts are barred, my lord. And the present property it's a Wakaf property. It is to be decided by the tribunal itself. So when it's a tribunal, the defendants, the respondents, my lord, the respondent plaintiffs, without exhausting the remedy of the tribunal, they approach the civil court, burdening the court. Now there are some judgments, my lord.
Yes.
I am on behalf of the petitioner. The matter is related to expeditious hearing and dispose of the appeal.
What is the miscellaneous appeal for?
Injunction.
This application under Article 227 of the Constitution of India is a
95, my lord, I appear on behalf of the petitioner, my lord.
Yes.
But in a suit for declaration and permanent injunction, I am the defendant. Now, my lord, by the impugned order, the applications under Order 1, Rule 10 and Order 6, Rule 17 has been allowed, filed by the plaintiff hearing. Now, my lord, kindly takes up the application filed by the plaintiff, page 34, my lord. Application under Order 1, Rule 10. Now, my lord, what the plaintiff states, my lord. Paragraph 2, my lord, plaintiff has filed a separate application for temporary injunction under Order 39, Rule 1 and 2. Page 34, my lord. Annexure C. The case is made out at para 6 and 7, my lord. Completely a new case has been made out.
Who are you?
I am the defendant.
How will be affected?
No, my lord. Yes. Now, kindly, my lord, takes up my written statement, page 27, my lord.
Yes.
I say, my lord, I am the owner of the suit property. Now, my
You are
lord,
the owner of
I am
the
in,
suit property.
I am in possession of the suit property. Now, my lord, by this amendment, my lord, this similar application has been filed in the Order 6, Rule 17 also. This, my lord, para 7, my lord, sees that IC Eco Park thereafter filed his report dated 31st of October 2022, and such report it is observed that one Babosha Mandir within Ram Mandir premises is claiming to be in possession of the suit property.
Yes.
And my lord, in the plaint, my lord, he states, my lord, I am in possession of the suit property. Completely a third case has been made out. He relies upon a report filed by the police who is saying that who is in possession of the suit property.
Where is your written statement?
Page 27, page
27.
27 is the relevant part, my lord. It starts at page 16. And thereafter, my lord, the original defendant died. The substituted defendant adopted the same written statement, that is at page 23.
You have raised Mandir.
Yes.
Yes, so you have also admitted this Mandir.
Yes. Now, my lord, no. What he is trying to make out my lord, I am stating, my lord, that I am in possession of the suit property. And now, my lord, he states, my lord, he is relying upon a report filed by the police authorities who says, my lord, that one Babosha Mandir within Ram Mandir premises is claiming to be in possession of the suit property.
Yes.
Now, my lord, he is trying to implead. Now, my lord, on the same breath, in order 1 rule 10, my lord, then our names has to be struck out.
Why?
Yes, because now he's claiming
That you apply. That you apply
No, no,
for
that-
striking out of your name. You apply
that he has to do. Milord, on the same breath, Milord, he is shifting his claim to the now newly added newly added defendants.
Anything more? This application under Article 227 of the Constitution Yes, next.
36 lordship in application for expeditious hearing.
You are appearing. Yes, please wait, please wait. This application, expeditious hearing for what?
Lordship, suit for eviction of 2001.
What is the
And
stage of the eviction suit?
still trial has not commenced. And Lordship would kindly come to page 10.
Order 22, Rule 4 application.
That has been allowed on the last date on 7th of August. And amended plaint is to be filed, that I will file immediately. But Lordship would kindly come page 10, already at that.
Yes.
My lord, I am referring behalf of the petitioner. My lord, I am praying for not today, my lord.
Why?
Advocate on record, Mr. Shoyal Kumar Maiti, suffering high fever, my lord.
On the prayer of the learned advocate for the petition hearing of the civil division applications. Yes, call the next matter. None appears for the petitioner. Yes.
My lord, I am for the petition, my lord, in this case. My lord, I have come up against an award passed by the Lok Adalat, my lord, which was obtained fraudulently by the claimant. Not for setting aside of the award, my lord. Lord, if I may invite your lordship, not to the impugned award, my lord, if you said the very last page, lordship will kindly come to. Lord, this was the award passed. 4 lakhs of rupees.
But you are also present.
Lord, I was also present. Lord, it's only, my lord, thereafter I came to know, my lord, it has been obtained fraudulently. My lord,
What fraudulently?
my lord, the victim, my lord, the injured claimant, my lord, said that, my lord, he was injured in an accident dated 22nd April. On that basis, my lord, this award was passed. FIR was lodged. Some medical documents were produced, my lord, on the basis of 22nd April. Thereafter, my lord, after making payment, my lord, the difficulty, my lord, was we believed and we believed those documents. My lord, we got the documents, some other documents, that the same victim, my lord, he was injured 1 week earlier, 15th April. Different FIR was lodged. He was in Patna on the date of this second accident, on the basis of which, my lord, this award was passed in Uttar Dinajpur, my lord, on the basis of the second accident, my lord. He had suppressed the first accident. He suppressed, my lord, that on the date of
he may have suffered 2 accidents.
That cannot be, my lord, that because on the date of second accident, my lord, when he was in, when he showed that he was at Islampur, my lord, he was having his treatment at Patna. 400 kilometers difference. It cannot be. My lord, I've got documents to show to your lordship, my lord. And that is, my lord, it was only a matter of 4 lakhs, but my lord, this blatant fraud, my lord, should not be allowed to go scot-free. More so, my lord, I have made the payment. Still, not I am here before your lordship, because, my lord, at the time of making of payment, it was not known to me. Thereafter, my lord, all these documents, my lord, your lordship, my lord, there are judgments, my lord, this, my lord, any, my lord, award or any order passed, my lord, on the basis of fraud is a nullity, my lord. One should not be allowed to, my lord, go. My lord, I would be seeking, my lord, my lord, I have informed the police also, that also I have annexed, my lord, the police has been informed about this fraud being committed, my lord. But, my lord, this should not be allowed to go scot-free, my lord. Your lordship will kindly allow. My lord, there are certain judgments, my lord, where the recovery right has been given. My lord, after the award, my lord, it was, my lord, found it has been obtained by way of fraud.
Yes. Call the next matter.
I'm grateful to your lordship. Naam diye, sir? Sorry. Naam diye?
Yes. Lord, I'm the petitioner before this honorable court, and my lord, petitioner is a defendant in a partition suit filed by the plaintiff. Not plaintiff completely stating a false statement that he is in possession of the suit property, file this partition suit. My lord, if you lordship kindly come to the plaint, my lord can find in the plaint, suit property has been, the address of the plaintiff has been given 114E, Dr. Suresh, my lord, plaint is at page number 9. Suresh Chandra Banerjee Road.
What is the impugned order?
I am coming, just coming. Now I will like to draw your lordship kind attention to page number 39. My lord, this is actually what is happening, my lord. The plaintiff is residing outside the suit property for last 30 years. False statement has been made in the plaint that he is residing over the suit property and capturing some portion. My lord, kindly see, he was a railway employee, and this is the pensioner.
What is the impugned order?
My lord, he filed an application in the 12 May 2023 that that defendant should hand over a set of key to himself as well as direction upon the local PS to implement that order. Order was passed again, my lord, on
Yes.
one implementation of court's order was petition was filed on 8/11/2024.
Implementation of the order of injunction.
Now, order dated 19th order passed in the petition
19th of September. Where is that order?
My lord, I've challenged this order also.
19th of September, you have also challenged.
Lord.
Where is that order?
My lord, first, here is this order, my lord.
Oh, there is a certified copy.
Certified copy. So one thing I put in my submission. But my mother was the original landlord, owner of this property. She executed a will in my favor. The probate proceeding is going on. The opposite party is also taking part in the filed his objection, and hearing is going on. I filed an application for stay that has been also rejected. Now, my lord, what is happening? This implementation of court's order petition was allowed, and police is coming every day and threatening me, if you shall not allow this person to enter into the property, then I shall arrest you. Day in and day out, my lord, he is being threatened by the police authority. Police is, my lord, I submit before this honorable court. Police is acting just like a hooligan. It is coming and threatening day in and day out. While the plaintiff, my lord, the plaintiff, his own identity card shows that he is residing outside the suit property for 30 years. My lord, kindly come to page number 12.
So you are directed to hand over the duplicate keys.
Yes.
Where is that order?
My lord, the first input order, my lord. First impugned order. Actually, the learned
15th of September.
Where
is that order directing you to hand over the?
No. Actually, learned trial court stated to make cooperation between both the parties.
Not to restrain him from entering into the property.
Not to.
Thereafter, an application under 151 was filed. Why did you not challenge this order for this long time?
Well,
19th of
that
September.
I've explained because he was not properly advised for this. And the main problem is the second order.
Yes.
Main problem is second order.
If the first order is there, second order.
First order is there. I made the explanation.
Second order has to be there.
Second order
cannot violate until it is.
A person kindly come to page number 12. Kindly come to page number 12, paragraph number 5. Kindly one similar. A person stating a wrong thing in the plaint, he has been granted this order. Miller, kindly come to that the father of the mother of the plaintiff residing in one room on the page number 12, paragraph 5.
So this order was passed 19th September on a contested hearing.
Miller.
So
Miller, I raised objection that he is residing outside. Miller, people also Miller, kindly come to my objection.
exactly that would amount to staying the order. Without hearing after 1 year, I cannot. List the matter under the heading motion in the monthly list of December 2025. Yes, call the next matter.
My lord, I beg to appear for the petitioner. Item number 41. My lord, this is a custody matter, my lord, where an order for interim visitation has been passed, my lord, which I have challenged and come up here. The thing is, my lord, the child is 9 years of age. And of course, my lord, I shall not disturb the court with, my lord, the jurisdiction of the court under parents' petri, my lord. But, my lord, the thing is only one page I would like to point out. My lord, kindly sees page number 176.
Who are you?
My lord, the mother. The child is in my custody.
Yes.
My lord, the order has been passed, 3 days of interim visitation at the court for 1.5 hours. Yes, but my lord, while passing the order, the court did not consider the previous occasion on which the predecessor judge of the same court interacted with the child and recorded certain things kindly 176.
What is the recording?
The child does not want to see the father, does not want to at all interact with him. But the thing is, my lord, he's suffering from a fear psychosis, which perhaps arises out of this.
That much of tutoring you have made.
Perhaps.
That much, perhaps. Of tutoring you have succeeded.
Kind, my lord, considers this. My lord, he has a.
Sir, please consider the welfare of the child.
Absolutely, my lord. Considering
Please consider the welfare of the child. So the tutoring was to that extent that the child do not even want to talk with the meet with the father.
My lord, he never saw the father. He never saw the father. The thing is, my lord,
let this process start. Let me see.
It should start. My lord, the only thing is, practical situation.
From your submission, it appears that from 3 days it used to be extended to 5 days. I think this
as my lord, as my lord would please. But my lord, the thing is that my lord, on the last occasion when the child was to be brought in, my lord, he was tired. Clung on to the steering and the directed the constable and the advocates. We went. The father went to the car. He did not want. This is the situation.
So you have to make the child understand so that he goes to
the
father.
Every attempt,
to make the child understand that he has to go to the father.
Another observation is
file an affidavit stating what steps you took for making the child understand to go to the father.
Understand, Milord, what
you file an affidavit stating what steps you took.
If minor says
child,
minor
will meet with the father.
Minor will interact with the child once. Once Milord will interact with the child, and Milord, whatever is Milord, then of course the welfare of the child has to be given Milord ultimate priority. Absolutely, but only the practical situation is that Milord, he cannot be forced. He cannot be can't do anything. That is the issue. And of course, another observation has been that any third party may not be allowed the child. The practical fact is that he has a deep attachment with his stepfather, and this one line has been added only on consideration that the stepfather would be remarried. Remarried, yes. Milord, his stepsister is there. Milord, there is a deep attachment. And Milord, without perhaps the fear is that his stepfather will be taken away from him because of this whole situation.
You are responsible for that.
Nobody is responsible. The child, Milord, he has a
4 years child.
9 years. He has a mind of his own. He has a mind of his own, Milord.
Yes.
Milord, why not you kindly interact with the child once? Milord, that would Milord perhaps solve Milord.
The best person to interact with the child and to make him understand as to the role of a father in the development of the child. It's you who have to make him understand. No third party can make him understand. Sir, it's your duty. Please consider the welfare of the child. You can fight with your husband.
There is
no difficulty.
You can fight. Perhaps Milord.
Not the husband, ex-husband. You can fight with him. No difficulty. After all, he is the father of your child.
Absolutely.
You cannot deny that fact.
There is no
deny not the fact that he is the father of your child.
There is no denying, Milord.
Yes.
Milord, that is a fact, Milord. But the practical situation is that he cannot be forced, Milord. There must be some, Milord, person in between who has to make the child perhaps understand.
Who can make the child understand?
Perhaps a trained person, who is trained. It's the name of child psychologist.
Suggest the name of
I do not.
person. I will appoint.
I shall come back with the name.
Yes, come back with the instruction. Suggest the name of a trained person who can make your child understand the importance of the father.
That I
in the
shall
life
have
of
to
us.
take instruction of, my lord.
Yes, please
shall have to take
take instructions. Please suggest as to who should be the best person to make your child understand.
There cannot be any better person than mother, because I was no. But the thing is, my situation.
You as an advocate, please instruct your client so that she makes her child understand.
My lord, if my lord is inclined to dismiss my application, my lord, if my lord is inclined to dismiss my application.
I'm not inclined to dismiss your application. Since you have said that you will take instructions, I'm keeping this. Please take instructions. Please see that how this situation can be improved. Ashun, on the prayer of the learned advocate appealing, how much time you want? Yes.
2019 matrimonial suit, my lord.
What do you want?
Not praying for an expeditious disposal, my lord.
What is the stage of the matrimonial suit?
My lord, PW, my lord, the petitioner husband.
Any alimony order has been passed?
That is, my lord, being complied with regularly.
You are complying with?
Complying with regularly, my lord. My lord,
what is the stage of the matrimonial suit?
My lord, PW3 has, my lord, discharged. PW3 has been discharged.
PW3 evidence completed?
Completed.
No, further evidence of PW3 on 7th of November.
Yes. My lord, PW3, my lord, is pending. PW3 was commencing, it is pending.
Application under Article. Yes, 43.
Unfortunate degree holder, unfortunate award holder is the petitioner before your lordship.
Yes, award holder, degree holders are unfortunate.
Praying for an expeditious hearing of the title execution case.
Strategy, senior advocate is moving an application for expeditious hearing.
That shows
Liable to be rejected with
the
cost.
gravity of the shows that how small
Liable to be rejected with cost.
shows how small the senior advocate is. Just the other.
And what would be commensurate with your status, Mr. Chair?
Then it's zero. Then it's zero. That is perfectly fine.
Yes.
So what happens is, Virat, I have obtained an award, 34 dismissed, 37 dismissed, SLP they have filed, they've just filed and kept it pending, no stay.
Which is pending, SL.
Effective. Then, now what
Defective, Mr. Chatterjee.
Even if you stay in the meantime, I don't have a problem. My 2017 Milord execution, the court is continuously granting time even today. This is the last order. Have a look at it. If there is
Mr. Chatterjee,
no problem.
You can apprise the court. What is the affair? What is the position of law?
That's crisis. We have. Milord, why they are not praying for stay is that there is a degree of 43 crores. Because if they pray for stay, they'll have to put in the money.
Award holder was directed to file the status report of the SLP on the next day.
I will.
And the stay order.
No, we filed it.
Award holder.
We filed the.
We filed it.
No, award data, not the award holder.
We have filed it.
They did not.
But 4th of September, award data was directed to file status report. A further date has been.
No
Mr. Chatterjee, when the SLP is pending, the learned executing court is when the SLP was filed.
Long back.
No, not long back. 2025 SLP. In September.
The SLPs which are being filed in a day or two, they are being listed. If you want to.
That is.
The problem is they will not move it because there is a degree of 43 crores against them. Because moment 43 crores comes into play, they will have to put in the money.
What is the challenge in the SLP? 37. 37 is under challenge.
So let them pay and take whatever time they have to take. I have no problems.
No money
But
paid for the
not
last
a single amount of money paid after 37.
No.
I'm sorry.
From 2010.
From 2010.
From date of termination.
This application.
So now the Supreme Court says if there is
73.
There is
no stay within 6 months, it has to be disposed of.
Within 73. Okay. So
I just have one copy, I'm sorry.
Then let the other side come. Let the other side come, so it has to be. This application under Article 227 of the
It's a matter of usual course.
Case of That is why purposely Mr. Chatterjee took it back.
I
If you want
understand.
to rely upon that, because the other side, then I have to direct you to serve, let them
No, no.
come, I will decide
I
that.
bow down. I was only saying that when the Supreme Court feels that execution applications should be
Consider
disposed of in
because the
6 months.
special leave petition is pending. You have lodged a KVA.
I lost the KP. I am on KP.
You can take steps also.
So the difficulty is, I am out of pocket. There is a money award of
I
43
appreciate
crores.
that. But what can the executing court do when the special leave petition is pending? Apprise of the provisions of law.
But I
You
trust
say that
But
is
my lord,
where
yesterday
special leave petition is
when they
there,
said that the
a
defect was
direction for expeditious hearing here. What will the executing court?
yesterday, my lord, the time was taken on the pretext that defects have been cured. I produced the records from the website of the Supreme Court which show that defects are still pending from 13 June 2025.
Yes, call the next
I'm
matter.
ready.
44 married under the petition.
This is expeditious disposal of the consumer complaint pending since 2022. my lord. The complainant's evidence has been completed.
This
And but one application for interim relief is pending for the hearing only. Affidavit in written objection is complete.
IA is pending.
IA, that is for interim order. Affidavit in opposition is completed, my lord. Next day on 16th December 2025 for final hearing.
This application, next date is
16th December 2025 for hearing of the IA.
IA is the interlocutory application.
Interlocutory application.
So that has to be disposed of first.
Yes.
This application under Article 227 of the Constitution.
Is valid in according to the Act. 3 months time.
Yes.
Yes, that whether last occasion you lost whether my landed paid to public report. How many when again thinking donors are in the city?
Yes,
Yeah, Lordship.
You have filed the affidavit.
No, your Lordship has given me a liberty to give me a to give a report so that your Lordship could peruse that, and if your Lordship finds out fit, then our Lordship will allow to file an affidavit.
No, I have given you.
No, your Lordship, on last occasion.
Yes, what is your instruction?
Instruction is, your Lordship, on page number 32, the policy which they have relied before the landed trial court below was issued physically from Durgapur. From the Durgapur office, issuing office is mentioned in the policy itself. Your Lordship, kindly come to page number 32. And it's issued through check. No online, nothing, no transaction has happened, your Lordship. You should kindly come to the page 32.
Yes, Mr. Bonik.
Now I am submitting whether the lordship finds.
What is this?
Mother, this is the mother, the Vicky donor who resides in the district manor Birbhum achieved. My lord, the ODC is, my lord, online, my lord, issued the policy. Can you see? And my lord, there are 13 policy also, my lord, are communicated.
Yes, then you file an affidavit. Let him controvert.
Yes, sir.
Your lordship, kindly see my.
Let him file an affidavit. He has only the instructions.
Yes, sir.
The when can you file this affidavit?
At least a week's time, Your Lordship.
On the prayer of Mr. Ganguly, learned advocate. Nothing will happen. Yes, call the next matter. Yes, fixed matter, supplementary fixed matter. Supplementary fixed matter. Yes, next. Yes, call the list. Then none appears for the petitioner at the time of call, no account. None appears.
In this matter, my lord, last occasion, your lordship adjourned the matter on the ground that the petition, the opposite party already filed a writ petition before the Honorable High Court. On the
Common roof, common wall.
Yes, my lord.
Yes, what happened?
This is the order, my lord. The already order has the writ petition has dismissed, my lord, on the ground that they have not willing to pay the fees of the learned executive engineer for
Yes, now, what is the order under challenge?
order under challenge, my lord. The we have challenged. We have
That is the opposite party.
Last occasion they have appeared, my lord.
Yes, last occasion they have appeared.
It is
Yes, what is the order?
order, my lord. We have challenged. We are the developer, my lord. Without impleading us as a party, the injunction application has been passed. Challenging that, we have filed an appeal, my lord. And after
What is the order of injunction?
they have, my lord, that is
Not to demolish.
not to demolish. The status quo, the whole building, my lord, has been
The suit for.
for suit for declaration and permanent injunction, my lord. And challenging that order, we have filed an appeal, preferred an appeal, and the leave, along with the leave.
You are a third party.
Yes, my lord. I am the developer.
You have preferred a miscellaneous appeal.
Miscellaneous appeal, but after admitting the appeal, the court, the learned appellate court, passed an order that that is the internal page, the impugned order, my lord. The first order, appeal is admitted. That is 4/11/2024. And subsequently, the 6/11/2024, the court recorded that we are not the necessary party. So it's been challenging the all both the order, my lord. I have preferred this revisional application in the in my written in the written statement of the owner. It is specifically mentioned that we are ready to deposit the amount if any damages caused, so that they can.
Show me the order passed by the learned trial judge.
It is, my lord, the first the impugn order.
5th of October 2024.
October 2024. একবার জানিয়ে দে সন্তুষ্ট।
Yes, if the owner does not want to challenge, what right you have?
My lord, owner has in the written statement, as per my contention is that in the written statement, owner specifically mentioned that we are ready to deposit some amount. If
No,
the
that is the different thing. Why the owner has to challenge? What right you have? You only have a right to construct.
yes, we are
You do not have any right to.
I am the sufferer in the.
Maybe you sue your
Then my
the owner.
Then, my lord, kindly make it adjourned for this day. I am late by Mr. Rohan Banerjee. He is arguing one matter.
Banerjee is a busy counsel.
Yes, my
It's
lord,
very difficult.
Arguing one matter before court number 24, my lord. Kindly fix it at, and the opposite party is also not there. If your lordship kindly fix it on the Thursday, I shall.
No fixing now. Adjournment, yes. I will
But
be.
my lord, I am the.
On the prayer of the learned advocate for the petitioner, hearing of the civil division application stands adjourned. Yes, next.
My lord, kindly retain its position, my lord, because I am the vote sufferer in this matter, my lord.
Yes, next. Daily list. 49 কি fixed আছে নাকি? Yes. Who is appearing? None appears for the parties. The hearing of the civil division application stands adjourned. Yes. আর আছে সাপ্লি?
For 7 na 248. 248.
But I appear for the petition. Madam, let me place it. No, Lord, on the last occasion, an adjournment was paid. We lost, Lord, many times for this. The matter went down. After several attempts, I have been able to, Lord, satisfy your lordship. The matter involves urgency. But I tell you, lordship, what happened?
You are satisfied in the
urgency. At least I know what urgency my lord has fixed it. Lord, wife, defendant is the petitioner. The suit filed by the husband, desertion, cruelty. Not husband, section 36, being for 3 lakh rupees per month.
It's section 36.
Yes, in the suit.
3 lakhs?
3 lakhs, Lord, 1 lakh 50 for the daughter, 1 lakh 50 for the wife.
What is the husband doing?
I'm coming. Lord, the husband filed in terms of Rajnish versus Nia. Lord, his affidavit of asset which he filed the court that was not considered. Court considered his earlier year's income. Court that 60 lakhs per annum after deducting net income. So court granted us 1 lakh for the daughter and me.
What is he doing?
Now he is the vice president of DLF. He is earning senior vice president 1 crore 70 lakhs per month. He travels per year. He travels. Daughter studies in Lamatin. I have calculated. I have asked them to bring the chart. Per month, the expenses is more than 1.5 lakhs. Daughter, she's a very talented girl. I tell you, lordship, she participates in poetry competition, writing competition throughout the world. This is a talent which the father should support. Company. So, one. Just take the improved order once. Challenge. Your dealers will get the first order dated 29th November, 31st August 2023. Can you take that order first?
Yes.
Dated 31st August 23.
Yes.
Then we filed a 151. Court did not entertain that. Can you take this order? Effective order. Can you take file the wife file 6
seeking a sum of 1,50,000 per month each for herself and the daughter as alimony pending on the ground that she has no source of income to maintain herself. Understand what is the package? He is an IIT Ahmedabad graduate.
And the wife is?
Wife not, she was working earlier, that's stated, admitted his income, she had to quit because of the daughter's education. Now, husband by filing telling same suppressed the material fact and not come she is that is earning 7 to 8 lakh gross per month. Gross per month, husband himself says, by working as a general manager, the parties have filed hard affidavit. As per the affidavit of assets, the liability of the wife, the details of income is not applicable, and the husband is working general receive it. It transfers from the affidavit to the husband. The market. That is also stated gross salary including 62 lakhs per salary is 44.44 lakhs, that is 3.67 lakhs. As per IT return, the assessment year 18-19, gross salary is 76 lakhs 54,000 and net tax payable 20 lakhs 44, ultimate tax payable 21 lakhs. As per IT return of 2021, gross income is 60 lakhs 17,000 and the net tax payable is 18 lakhs, actual tax payable is so and so. So from 60 lakhs, he deducts this amount. Further, wife is a graduate diploma, communication management, and last is 2,50,000 per month. To submit the without wife. In the event it is submitted on behalf of the wife, that previously she used to earn some amount, but not she, and now she has no such income. Provisions of the child is, it is not only legal duty, so and so, and can it turn the page below? Then can it come to the last paragraph? Having considered all the above, having considered the materials and records, social and financial status of the parties, I find the sum of which 50,000 per month of maintenance of the wife daughter from the date of the order. Challenge the application. The application was filed on 6 August 2020. Now, kindly take one document which is not annexed here. This is the husband supplementary affidavit he filed before the court below.
Application filed on
6th August 2020. এটা জোসেফকে দিন তো আমার কত
August 2020.
2020. But I have made the calculations for your lordship. My lord did not. Kindly have a look at this document. Lord, this was filed on 12th May 22 and the implemented 30th August. Kindly come to return on page 5. I'll take your lordship to the improved order one more time. My lord, kindly take the first page of the improved side by side this. The court has taken into consideration assessment 60 lakhs.
Which page you are placing?
Page 5 of the supplementary. Page 5.
5.
Mark kora nahi.
After 3 there is no pagination.
Amarta mark kora ache. কি দিয়েছো? সাপ্লিমেন্টারিটা যেটা সাপ্লিমেন্টারি যেখানে পরের অ্যাসেটটা লাগানো ছিল আর এটা নয় হাজবেন্ডের যে সাপ্লিমেন্টারি কারস কালে গট দ্যাট যেখানে 2021 22 অ্যাসেটটা দিয়েছিল সেটা কোথায়
Not legible, Mr. Chakraborty.
এই যে page 5
Page 5 is there, nothing is legible on the left hand side. Nothing is legible.
এটাতে legible কপি আছে এটা নাও খুলে দাও বার করে দাও Now, this was filed on 2022 before the improved order was passed. So 21-22 assessment year, 41,000. The available document, available material was not taken into consideration. The taxable income of 87 lakhs. Court passed an order of 1 lakh maintenance on the strength that his income is 60 lakhs.
No, 87 lakh 41,000. Yes. Of that tax payable is 26 lakh 16.
I know.
So that is to be deducted.
Adjusted total income under AMT where applicable.
Yes, what is the adjusted income is 8741.
This is the net income on which he pays tax.
Yes.
This is the income on which he pays tax.
Yes, no dispute on with regard to that. 8741 is the income on which he has to pay tax. He pays tax of 26 lakh and 16,000. That is to be deducted.
So if that is deducted, his tax come to 60 lakhs?
Yes, so that was considered.
No, subject to correction. Can you come back? That is before deducting 60, then tax deducted 18 lakhs. 42 lakhs. 60 lakhs, then tax 18 lakhs.
No,
so,
this is for 21.
Yes.
No. 21-22. 21-22 was not considered.
Judge, it was filed by his husband on 12th May. That's my first ground. He did not consider this. The trial judge did not consider the available material. On the basis of an earlier year's income tax return, the trial judge passed this order. So on 42 lakhs, if we take 42 lakhs, my lord is at the implement 60 lakhs, tax paid 18 lakhs, so 42 lakhs. 42 lakhs divided by 12 months, 3.5 lakhs. On 3.5 lakhs, he pay 1 lakh. If the income goes up to 42 lakhs now, because 60 lakhs from 87, he paid 26 lakhs tax. So from 60 lakhs, then if my lord decides on pro rata basis, it should be 2.5 lakhs. The basis on which the judge has directed. Not 60 lakhs was the income calculated. Income tax 18 lakhs comes to 42 lakhs. 42 lakhs divided by 12 months, I think it's coming to 3.5 lakhs. Amongst 3 lakhs, the court did 2 lakh. So almost 30% of his income. 7 lakhs deducting tax of 26 lakhs coming to 60 lakhs. 60 lakhs means 5 lakhs income. 1/3 of the 5 lakhs would have been 2 lakhs rupees at least. We have paid for 3 lakhs. Now, can you take one more document? We are managed the civil revision application, Lord. Can you take this? So this was brought to the notice of the judge, Lord. Can you come to page 130 of the revisional application?
Yes.
Lord, this is the annual published by DLF. I was going to got the page 130. আর ওর affidavit টা তো যেখানে বলে যে DLF এ কাজ করে. Lord, kindly come to
130 are the pictures of certain projects.
দেখাচ্ছে I'm showing. But my lord, kindly hold your chair. Come to 138. মাথা ঘুরে যাবে. Kindly come to 138.
Yes.
See entry number 65. Entry number 65. That.
Yes.
Obhi Bhattacharya, 17 senior special arrears how much is earning? 16 on 2023. In
yes,
he has admitted that he is working in এটাই তোমার অরিজিনাল তো জেরক্স কপি দাও না জেরক্স দাও he has admitted he is working in DLF because in trial court he submitted his office address, that's DLF. In Act 8 case he submitted his office address. So today he is earning 50 lakhs a month. আমাদের ক্যালকুলেশনটা তো যেটা আমরা চেয়েছি.
Yes.
Now have a look at this. He travels the public just sent to the daughter. He has sent it to the daughter.
Yes.
Lord, at least some husband earning not 15 lakhs a month, the daughter cannot pay off the educational expenses in Lama tenure. My lord knows how expensive it is in today's time.
I do not know.
Now we have prepared a chart for my lord for consideration.
Yes.
The entire expenses of the daughter.
Show me your affidavit of assets and liabilities.
Yes, we are carrying it. আমাদের affidavit of assets দাও. আস্তে তাড়াহুড়ো করার দরকার নেই. He did not dispute that I am not earning.
Show me your affidavit of assets.
This is my affidavit of asset. A copy though. Actual too. Kindly come to internal page 3.
Yes.
And I have also, my client notes, he has very meticulously done a calculation. Whatever savings he did have, everything is gone by the time to raise the child.
Where is your application under section 24?
Or
36,
section
whatever.
36 application, my lord will get that note at page 12. Not very happily drafted, but in the affidavit of asset, everything was stated, my lord. In the affidavit of asset, everything was given.
Chakraborty, you are blaming the learned trial judge for having used section 30.
That was available before the learned trial judge, the document.
You have not allowed me to complete my observation.
I'm sorry.
You are blaming the learned trial judge for having mentioned section 37 application.
No. Thursday. Wait, তুমি এখানে এসো না।
4টের সময়
শুভ হয়ে গেছে না
আজকে
সেটাই বলছি। তাহলে আমাদের আবার Not, it has to commensurate the income of the husband. I am not asking for something which is absolutely not unacceptable. The court did not consider the available document. I will show your lordship my asset and his asset and what he is doing today. Lord, court has, I have twofold submissions, Lord. I'm just giving you lordship, Lord, the outer line. One is it should be from the date of application. That's the law.
Mr. Chakraborty, that is the different thing altogether.
That is the law. And second, I prayed for 3 lakhs.
Happy with the quantum from the date of the application is one thing.
That is that
If I have to go to the quantum, then what is
not the present bringing the DLF income because I will go to documents because his present assets should come. My lord may direct us to disclose another affidavit of asset before your lordship. Can you pass that order? I'll find that within a week. Another affidavit of asset disclosing till date what is the income.
Where? Here?
Before your lordship. Let us file that. My lord may look into it.
No. For the first time.
I beseech your lordship.
No. Do that before.
Because we have done it earlier. We have done it. He filed 3 assets.
I have to, Mr. Chakraborty, I have to consider on the basis of the materials which were on.
So the material that was available before the honorable learned judge
only those
was 87 lakhs. If we go for it, minimum 2 lakhs should have been done.
Consider that because
I'll come back.
That you have shown one side of the coin. So let me see the other side of the
If
coin.
it has to be Mr. Mukherjee, Lord, Mr. Mukherjee has been
You have to see both sides. Then Mr. Mukherjee, I will also see both sides.
Lord, Thursday at 3:30 then.
No. কবে ফাঁকা আছে?
তুমি আমার সঙ্গে
কবে ফাঁকা আছে? 4টের সময় কবে ফাঁকা আছে একটু দেখুন।
কাজ গান হচ্ছে কার হবে না বৃহস্পতিবার শুক্রবার আমি নেই বলো না একটু
নেক্সট
বৃহস্পতিবার কবে? বৃহস্পতিবার অসুবিধা কি আছে?
23 তারিখ আছে, 23 আগস্ট 22nd.
Not 22nd, Mr.
Possible.
21st,
21st not available. Yes, next.
Then next week 26th, 26th, 27th.
Have to go to September.
No. August.
Which
August.
Available in my diary. Both of you are.
Finally, she's not the daughter will go for higher education. That is the difficulty.
That's
not she had gone to London to attend a poetry competition. Everything is being done by the mother. Father is not supporting anything. I'll show the expenses.
27th.
By our 27th at 3:30.
No.
27th at 3 p.m. Lord.
Heard Mr. Chakraborty. No, not at 3 p.m. It will be 4. I've handed up. So prepare another copy. No, you have another copy.
আমি এটা আমার ছিল সেটাই
Because these copies are not very legible.
May I do one thing? The documents which have not been given, I'll prepare a compilation for my lord and give it to your lordship.
Do that,
All the
but
affidavit
it
have
has
said
to be legible.
হ্যাঁ legible copy. এগুলো বানিয়ে দাও.
And income tax returns also legible copies because
whatever we have, he has disclosed, we will produce. If my lord had called for a latest affidavit of asset, not the latest income tax return would have been before your lordship, my lord.
Latest?
Yes. If I am ready to file.
Give you liberty maintaining this before the learned trial judge for enhancement, other things. So up to date affidavit, so you can wait.
We will do anyway, my lord, but on the available, it should have been at least 2 lakhs.
You have filed your income tax return. I'm not asking you. No, not for you. Your client for this year.
But I don't pay income tax return.
If not, I can give you some more time, 15th September. After 15th September, I can give you liberty to.
My client has filed, but I don't have any income tax.
No, I'm not asking you. That is fine. I know. I know that you do not have any income.
No income, so no return.
That I know.
No income.
No, Mr. Banerjee does not.
No income, no return.
Public admission is very bad.
No income, no return.
Next to other things.
Yes. Call the list.
Recall
Which matter?
MSME award. Two issues.
Maintainability.
Maintainability. The award was on the question.
According to you,
rent
it has to be under 34.
Yes. I'll just
yes.
In sentences, really, the award deals with my entitlement.
Yes, Mr.
The award deals with my entitlement under for rent. That's the award. They say that you are registered for services, though I was an MSME from 2001. They say you are registered for services after the date of the contract. And they relied on Shilpi Industries. And so therefore it is without jurisdiction. To that, I had shown factually that in the MSME award itself, it deals with the fact that I was already an MSME. So whether I'm registered as services after the date of the rent agreement.
So according to you, initial registration.
And what it says, when I show, Shilpi actually has been not considered to be the right. It doesn't lay down the right proposition. That's what the judgment I want to show, which is the later judgment after Shilpi. Shilpi says you have to be registered before the contract. Or rather, that's why they relied upon. I'm saying that Shilpi says that, but that's not correct, with great respect to my learned friend. Because the term used in the act is supplier. Term used in the act is party, not a supplier. That's how the distinction has been done. So any party can refer to the MSME if he is an MSME. It is not a question of being a supplier, then only you can refer. And that's what the subsequent judgment says. I've taken 2 points. One on the question of maintainability, which is section 34 is there. I refer to India Glycols. To remember. India Glycols, this is 2025, 5 Supreme Court cases, 780.
20, you have given that copy. 20.
Yes, we had given copies. 2025, 5 Supreme Court cases, 780. That's आपकी copy देश में मांगी थी ना था क्या correct copy?
No, it's not here, Mr.
I read the. My learned friend relied on some one English decision and on one another older decision. Yeah, kindly look at.
No. Sorry, Mr. Manj, you had given glycols. You had given that is in. Yes. Yes.
Paragraph 1, leave granted, second respondent SR Technologies, governed by the provisions of Micro Sunsearch, filed a claim before the Micro Facilitation Council, 28th October, Facilitation Council decreed the claim in the principal sum of 40,29,000. Interest with monthly at that time bank prevailing rate and dates under granted. Award of the Facilitation Council was challenged in a petition under Article 2, Paragraph 3. 2 to 6, 2 to 7 of the Constitution, by judgment in order dated 14, a single judge of the High Court of Telangana allowed the writ petition, sentencing the award, ground the claim was barred by limitation. The appeal by the second respondent, division bench by judgment had reversed the view of the single judge. The division bench come to the conclusion writ petition instituted by the appellant was not maintainable via the specific remedies which are provided under the special statute. High Court held that the appellant ought to have taken recourse to the remedy under section 34 of the Arbitration Conciliation and failed to do so. Writ petition could not be entertained. Observation the High Court has set out in paragraph 84 of the impugned judgment. Exactly the point. And also recalls in the Act, there is a provision that 75% deposit has to be given. So when they come under 2 to 6, 2 to 7.
Not required. But even
when they say.
Yes.
Otherwise,
but even then,
it is really defeating the statutory provision.
Yes.
Then no one will go under section 34 for setting aside. Everyone will file the writ and come and say, sorry, I don't have to deposit. Also another judgment which says no application can be entertained without that 75%. And this was precisely the ground. Then kindly come to paragraph 5, having held that the petition was not maintainable, High Court has nonetheless inquired whether the claim was barred by limitation and came to the conclusion following the decision of this court in the claim was timely. 7. Section 18 of the MSME Act provides for a reference to the Facilitation Council. Subsection 2 of Section 18 provides for the conduct of conciliation proceedings. Subsection 3 empowers the council to thereafter take up the dispute for arbitration or to refer it to an institution or center providing for alternate dispute resolution services for such arbitration. Subsection 3 of section 18 stipulates provisions. This is very important. I will ask me that question, and the amended act says, and you see subsection 3 of section 18 stipulates that the provisions of the 1996 Act, which is the Arbitration Act, shall then apply to the dispute as if the arbitration was in pursuance of an arbitration agreement referred to in subsection 1 of section 7 of that Act. 19 provides recourse against an award of the Facilitation Council following terms. No application for setting aside any decree, award, or other order made either by the council itself or by any institution or center providing alternate dispute resolution services to which a reference is made by the council shall be entertained by any court unless the appellant, not being a supplier, has deposited with 75% of the amount in terms of the decree. Awarded as the case may be, the other order in the manner directed by such court. Provided that pending disposal of the application to set aside the decree, award, or order, court shall order that such percentage of the amount deposited shall be paid to the supplier as it considers reasonable under the circumstances of the case, subject to such condition as it deemed necessary. In terms of section 19, an application for setting aside an award with the Facilitation Council cannot be entertained by any court unless the appellant has deposited 75% of the amount of the award. In view of the provisions of section 18(4), where the Facilitation Council proceeds to arbitrate upon a dispute, provisions of the 1996 Act are to apply to the dispute as if it is pursuant of an arbitration agreement under subsection 1 and section 7 of the Act. Hence, the remedy which is provided under section 34 of the 1996 Act would govern an award of the Facilitation Council. Okay. However, there is a superadded condition which is imposed by section 19 of the MSME Act that an application for setting aside an award can be entertained only upon the appellant depositing with the council 75% of the amount in terms of the award. Section 19 has been introduced measure of security for enterprises for whom a special provision is made by MSME Act by Parliament. View of the provisions of section 18(4), appellant had a remedy under 34 of the 1996 Act to challenge the award which it failed to pursue. In the judgment of this court in Gujarat State Civil Supplies, two-judge bench observed course of drawing its conclusion, proceeding before the Facilitation Council, Institute Center acting as arbitrator, Arbitration section 18(3) would be governed by the Arbitration Act. Appellant failed to avail of the remedy under section 34. If it were to do so, it would have been required to deposit 75% of dictatorial amount. This obligation under the statute was sought to be obviated by taking recourse to jurisdiction under Article 226, 227 of the Constitution. This was clearly impermissible. For the above reasons, we are in agreement with the view of the division bench of the High Court that the writ petition which was instituted by the appellant was not maintained. Then we'll kindly see 14. Parag Tripathi, senior counsel appearing on behalf of the appellant, sought to urge view of the facilitation to effect provision limitation of no application which has been affirmed in the additional impugn judgment suffers from a perversity. Hence, the petition under 226 ought to have been entered. We cannot accept this submission for the simple reason section 18 of the MSME Act provides for recourse to a statutory remedy for challenge and award under 1996 Act. However, recourse to the remedy is subject to discipline of complying with provision section 19. Entertaining of a petition under Article 226 or 227 of the Constitution in order to obviate compliance with the requirement of pre-deposit under section 19 would defeat the object and purpose of the special enactment which has been legislated upon by Parliament. For the above reason, we affirm the decision of the division bench by holding that it was justified in coming to the conclusion that the petition under 226, 227 instituted by the appellant was not maintainable. Hence, it was unnecessary for the High Court, having come to the conclusion petition was not maintainable, to enter upon the merits of the controversy which arose before the Facilitation Council. Then 16 is the submission, and then this is, my lord, the 3 judges bench, my lord, of the Honorable Supreme Court.
So it says that when a specific remedy has been provided, you cannot bypass that by.
And 34, my lord, I showed, my lord, section 2B2. It also says without jurisdiction is also under section 34. That's one of the obvious grounds. Because 34, you can't challenge, it's not an appeal. You can also challenge under limited grounds. Correct. Correct. In fact, my lord will recall one of the judgments of, my lord, in setting aside also uses the expression if the award is unreasonable, and which is a direct ground, my lord, under Article 226. So it has now, my lord, been, my lord, really, it's more akin to, my lord, a restrictive jurisdiction in setting aside than anything else.
Not an appeal in that real sense.
Not an appeal. Not an appeal. Because no appeal is permissible. And section 18(4) of the Micro, Small and Medium Enterprises Development Act against a reference as if it's a Section 7 agreement under the Arbitration Act. Therefore, all those things follow. Therefore, it's an award under the Act. Therefore, it
So
is
in effect, the provisions of the Arbitration Act with regard to challenge and
superimposed on that. Now, my lord, this is India Glycols. This is, my lord, as on, my lord, November. The judgment, my lord, actually is a little older, November 6, 2023. Now, my lord,
yes, but it has been reported subsequently.
But, my lord, I also must, my lord, be fair, though, my lord, my learned friends didn't give all this judgment. But, my lord, kindly look at, my lord, a 25 judgment, 2025, Tamil Nadu Cements Corporation. This is 2025.
NBCC?
No, NBCC, my lord, I'll cite. That is, my lord, says Shilpi is not correct.
Yes.
This is, my lord, Tamil Nadu Cements Corporation Limited. 2025 4 Supreme Court cases, page 1. I don't know whether, my lord.
5-4 has not been given.
2025 4 SCC 1. 2025 4 SCC, page 1. Because, my lord, now India Glycols has been referred to a larger bench.
Oh, India Glycols referred to a larger bench.
Yes. But no decision has come on that larger bench. Therefore, my lord, the law which is, my lord, decided, my lord, by this, my lord, is the prevailing law. Here also, my lord, will find, kindly come to paragraph 52. Lastly, an order or award can be challenged by the buyer only on deposit of 75% of the awarded amount, thereby restricting right to challenge the order award passed except on compliance of stringent condition when not prescribed, preferred under the CPC, treated as a condition for hearing a decision on the objections to the award. Then, my lord, the 58 is, my lord, on the question, my lord, whether a statutory remedy in that sense, my lord, writ remedy is taken away. And the reference, my lord, is at paragraph 64. Last paragraph, my lord, of that. In the light of the aforesaid decisions, we deem it appropriate to refer the following questions raised in the present appeal to a larger bench of 5 judges, namely, whether the ratio in India Glycols that a writ petition could never be entertained against any order, award of MSEFC completely bars or prohibits maintainability of writ petition before the High Court. If the bar provision not absolute, when and under what circumstances will the principal restriction of adequate alternate remedy not apply? Then whether the members of MSME who undertakes conciliation proceeding upon failure can themselves act as arbitrators of the arbitral tribunal in terms of section 18 of
So
the
this reference makes it clear, Mr. Banerjee, that
this is the law.
That cannot be an absolute embargo.
No, the reference says it is the law. Kindly look at the first question.
Yes, whether the ratio of India Glycols
But a writ petition could never be entertained.
Completely bars.
Correct.
Or prohibits maintainability of the writ petition before.
That's what India Glycols hold.
Yes.
And that is the reference.
Reference
has
says,
not been decided.
Yes, reference says whether the writ petition can be said to be completely barred.
Correct. Which means the writ petition now holds it is completely barred. That's what India Glycols.
India Glycols says it's completely barred.
When there's a reference, Malad knows the law which is still subsisting, Malad, is the law. That Malad also, Malad, Supreme Court is there, Malad, I've got
that. Is
that's the principle. Now, which way, Malad? I just want to be fair because, Malad, otherwise, Malad, I don't think my learned friend, Malad, have cited any of these judgments.
No, that is only one because Mr. Banerjee, it's well settled that this constitutional remedies 226 or 227 cannot be an absolute embargo. In certain exceptional cases, even cannot be a statutory remedy, cannot oust. And even finding some decisions in the other statutes also, which considers these onerous provisions. If the liability is so huge, then under certain circumstances, yes, 226 and 226 can be held to be maintainable.
So far as the
but it is rarest of rare cases, not a normal rule.
I am not, so far as a lawyer I'm concerned, I'm not at all disputing what is followed.
So
I don't think there can ever be a
finding, Mr. Banerjee, two line of decisions. As we all know that there cannot be an absolute embargo, even if there is an existence of statutory remedies.
I think eventually, because I've seen that in one of the cases, I remember sometime in 1988, 99, where they said 227 was also completely barred in one of the cases.
Yes.
Then they came back and said, no, it's a constitutional remedy.
Cannot
Can't be an absolute bar.
Cannot be an absolute bar. Now, certain exceptions are carved out where it says under those circumstances 226 and 227 is maintainable even if there is a...
In fact, question 2
yes,
is what it says. If the bar prohibition is not absolute, when and under what circumstances will the principal restriction of adequate alternate remedy not apply? Well, I think the India glycols got also influenced by the fact that there is a statutory provision which says you must deposit 75.
There are two line of authorities, as we have seen, also in surfacing.
Correct.
We find a line of decisions which says that 226, 227 is not an absolute bar. Under certain those exceptional 3-4 exceptions where 226 and 227 can be maintained. Now, recent view we will find that it says no. If in case of fiscal statutes and those things, where since in the surface it's a complete code by itself, so 226 and 227 should not be allowed to be invoked. That is recent 2024, 2025.
It really says should not be entertained. To say is not maintainable is really something.
Maintainable is a different.
It's
a
a different.
court's discretion whether to entertain or not. It's always within the discretion of the court.
I think now the law seems to be with India glycol because I find the language used is not maintainable. Which is the why the reference is there. Why the reference is there, but actually it should be. I'm sure when the final decision
because those statutes it must be L. Chandra Kumar when it came.
Yes.
Some statutes barred the jurisdiction.
At the first stage, it will come from the appellate.
So it says it's clarified. No, the 226, 227 powers cannot be taken away. You have to follow that. Then 226, 227 is maintainable.
Tribunals will not under 323A.
Yes, that was challenged. That was challenged from that. So those statutes, it has been said no. Even then you can. 1997.
100 or something.
So these powers, it has been said constitutional, these powers cannot be taken away by any statutes, even if by that. So
here, some glycol I find has actually gone to the extent of saying not maintainable. We affirm.
This is also 3 judges bench, 2025-4.
Correct. 3 judges bench.
Before referring to this, Mr. Banerjee, does it say with regard to 226, 227 maintainability? It must have referred to some.
Yes, my lord, it does, my lord.
Paragraph.
My lord, I'll tell my lord what is, my lord, perhaps the India glycol. If I may, my lord, just my lord, with most humbly I submit. If a section 34 remedy exists,
you have to go before that.
Correct. It is not a question of then a alternate remedy existing. That is the remedy.
Yes. That's the statutory remedy.
Statutory remedy.
So whether it bars the 226 or 227, that's the question. India glycol says no, you have to go before that. And 227, because 226 was entertained by the single bench.
Single bench reversed by the division.
Reversed by the division bench, says division bench was right. 227 could not have been.
Correct.
So in effect, it says that when it's a statutory remedy, you cannot.
Which I think, my lord, with great respect, my lord, makes some, my lord, logical, my lord, conclusion saying that if you have a section 34, then, my lord, everyone will challenge an award under 227.
Bypassing that pre-deposit.
My lord knows, my lord, our court, my lord, also entertains 227, my lord, from some of the directions of the arbitrator, which is not available under section 17. Which is not available. But, my lord, that means now a final award will also be challenged under 227. Whether, my lord, will entertain it or not. Entertainment means, my lord, whether, my lord, will consider the ground. Glycol says, no, don't.
Final award, there is
Same
a
thing.
remedy of appeal.
Same thing. Section 34 remedy is there. Therefore, my lord will not entertain a 2 to 7.
Yes, with regard to that, yes, the decision you appeared in that matter, Mr. Mukherjee was opposing you. I think in Jain Financial, the earlier round of litigation.
Correct.
Justice Nariman's judgment on that,
Correct.
on Civil Procedure Code, which said that it's a near absolute total bar.
Yes.
So on
But they
civil
won't entertain, my lord.
on Civil Procedure Code, that was the example which was cited, that you can also challenge a decree under 227.
Absolutely. But it will not be entertained.
Can also challenge, so that it has been held. So Civil Procedure Code, these procedures stand on a different footing. In that, it's a near total bar or absolute bar. That was the expression used in that decision.
I think that is, my lord, to put India Glycol in the perspective of, my lord, how the law is. I think that is what India Glycol is saying. Saying it is either an near bar or you should not entertain, because there is specialized procedure which is provided under both MSME Act as well as.
Even if it is maintainable or can be at least, so it's the discretion lies with the court. In a given case, court can, or
yes, though not according to India Glycol, but I would, my lord, personally say yes, in a given case, in the most, if I say horrific of cases, yes, perhaps yes.
Yes.
But that's why, my lord, I started by showing in the award that what the arbitrators have held. They have held no, you were registered. So that's a point. It has to be argued. My learned friend came and said, sorry, their contract was before, they are registered for services later, therefore you set aside. No jurisdiction. I'm saying no. This is an issue which has been considered. You raised this point. You raised this point before the Arbitration Council. Arbitration Council has held that because I was registered.
So in one way or the other, so if a decision is given one way or the other, whether under 227 can be interfered with.
Absolutely.
If there are two possible views.
That's right. Because then my lord is going into the merits of the matter.
There are two possible views. If one view is taken.
In fact, my lord, I will go to the extent of saying, even in section 34, my lord, this will not be a, because it's an interpretation. And I'll show, my lord, what Shilpi was, my lord, said, my lord, in NBCC. Kindly, my lord, look at that. Shilpi was relied upon.
Now we want to cite NBCC.
NBCC.
Yes.
No, this is to 2025. 3 Supreme Court cases, 440.
Yes.
Now kindly look at, well, first paragraph 2, paragraph 2. The MSME before us has a simple prayer. It seeks to refer the dispute that it has with the buyer regarding payment of its dues to the Facilitation Council for arbitration under Section 18 of the Act, which provides that, this is what I was saying, any party to a dispute may, with regard to any amount due under Section 17, make a reference to the Micro and Small Enterprises Facilitation Council. The appellant opposes this prayer by contending that any party can only be a supplier, and that supplier should have been registered under Section 8 of the Act even before execution of the contract. If not, the reference is impermissible. High Court did not answer this question. Instead, it permitted the parties to raise such objections before the arbitral tribunal. The buyer is in appeal before us, raising the same question as a jurisdictional issue. We have examined the text, context and purpose of the Act to arrive at a decision that Section 18 is not a restrictive and is a remedy for the resolution of dispute. And as such, it is kept open-ended to enable any party to refer the dispute to seek redress. For the reasons to follow, we rejected the submission that any party to a dispute is confined to a supplier who has filed a memorandum under Section 8 of the Act. We have also explained that the issues that have arisen in the decision of this court In Shilpi Industries versus Kerala, this is not what was relied upon by them. Hereinafter referred to in short Shilpi and Gujarat State Civil and Mahakali food products hereinafter referred to Mahakali Foods were very different from the issue that has arisen for consideration. However, for clarity and legal certainty, we have directed the appeal be placed before Honorable Chief Justice of India for referring the matter to a bench of 3 judges for an authoritative pronouncement. We'll start first the necessary fact before consideration. So even Shilpi was referred, my lord, but this is, my lord, what this court held. Kindly come to, my lord, paragraph 13.
Shilpi has also been referred to,
Yes.
To a larger bench.
But can you see what it holds?
Yes.
It says Shilpi is not good.
Yes.
Paragraph 13. The question of law for our consideration is whether an MSME cannot make a reference to the Facilitation Council for Dispute Resolution under Section 18 of the Act if it is not registered under Section 8 of the Act before the execution of the contract.
This is the issue here also.
In our case also, that is the issue.
Yes.
They say,
how it has been answered here?
Well, kindly come to paragraph 25 at page 460.
Yes.
The question that we are called upon to answer is whether the reference to the Facilitation Council under Section 18 of the Act is impermissible if the enterprise is not registered by filing a memorandum under Section 8 of the Act before the contract is executed. This issue was not formulated, discussed, and decided in any other judgment of this court, including the 2 substantive judgments. That. Under the Act, that is Shilpi Industries or Mahakali Foods, in these 2 judgments, it is worth mentioning such an issue was neither formulated nor discussed. We will explain this in detail while discussing the facts and the ratios of these judgments. Apart from the submissions of the appellant, that the issue arising for consideration covered by the decision Shilpi Industries as approved by in Mahakali Foods as on a specific query as to under which provision of the Act an enterprise which has not filed a memorandum of Section 8 would be barred from invoking remedies under Section 18 of the Act. Mr. Goval made the following submission. Then my lord, submissions are recorded. Kindly see paragraph 29.
Yes.
The text of Section 18 is clear and categoric. The words employed herein are any party to a dispute. The text any party to a dispute cannot be read as a supplier by adopting a process of interpretation by first referring to Section 17, then to Section 15 and 16, and thereafter in search of the definition of supplier to Section 2n, and finally stopping at Section 8 to hold that any party to a dispute will only be an enterprise which is registered under Section 8 of the Act. This meaning-making process to metamorphosize the clear text, any party to a supplier, is not the legal method to understand the true meaning of words employed by the legislature. The age-old principle referred to as the golden rule of interpretation is the words of a statute has to be read and understood in the natural, ordinary, and popular sense. Choice of the words any party to a dispute in Section 18 of the Act is deliberate. The legislative device of employing different expressions in successive provisions of the same statute is well known, maintained to effectuate desired process of the Act. Parliament had intended that any party must be confined only to a supplier or even a buyer, which expression is also defined. It would as well have used that or those very expressions. Court cannot substitute the expression any party with supplier and change the text, and consequently.
I think paragraph 40 it has been answered. After considering these definitions and other things.
But, that's why, my lord, I hesitate, my lord, to read judgments before my lord extensive. Because my lord is already reached, my lord, where.
I think paragraph 40 is the ultimate conclusion.
Yes. I have noted, my lord, yes. Paragraph 40, yes. 40. And then 42 deals with yes.
Then CP and the other decision was considered.
That's right. 40 says, having considered definition of expression supply and also having considered classification enterprise, micro, small, and medium with respect to each of which there is separate legal regime to be censored and different cannot enter in reference not registered, must be rejected.
Must be rejected. So that's the answer to that question.
Okay, for the 2001, 2011 contract data. Kindly just make some note of these. First registration of MSME is
facts.
Yes, very important, because to show, I want to show prima facie also, we are within.
Yes, first registration of MSME
is in 2011. This is noted in the award itself.
MSME in 2011.
Then lease agreement, which is what between them and us, 22nd May 2018, which is lease for 9 years for bar and restaurant.
That is the agreement in question.
Agreement in question. Normally, the period for which we ask for rent is 15 June 2019.
15th
June 2019 to 30th September 2022.
Yes.
Registration for supply is on 2020.
2020.
2020.
Yes.
And the reference is 30th August 2023.
30th of August 2023. So, according to Mr. Basui, since your registration was in 2020,
correct,
and the agreement was prior,
yes,
so could not have been done.
That's his point.
Yes.
To that answer is this judgment, which clearly covers the issue.
Registration is not the criteria for.
Supplier is the being a supplier at that time is important.
Yes.
And anyway, my period is from 15 June 2019 to 30th September 2022.
Yes.
So all counts, I'm within. Just wanted to complete this judgment. Kindly come to paragraph 40, 41 has seen. 42 is Shilpi.
Yes.
And kindly see what they hold for Shilpi. 43.
Yes.
In the first place, whether an enterprise is disabled from seeking a reference before filing a memorandum under Section 8 for registration never arose for consideration in Shilpi. More importantly, court did not examine any provision of the Act and the implication on their right to seek a reference under Section 18 of the Act. This was natural because the court did not frame an issue of registration. On the facts, the court also held that there was no proof whatsoever that the appellant had made any supplies as contemplated in Shanti Conductor's case. Though we are concerned about the interpretation of the Act, we may mention at this very stage that an admitted fact that the respondent has in fact raised 41 out of 53 bills. Kindly see, 41 out of 53 bills after its registration on 19 January 2016. Be that as it may, in view of the aforesaid analysis, we are of the opinion that Shilpi Industries, now kindly see,
not an authority on the issue.
Correct. Is not an authority on the issue that a reference under Section 18 cannot be made by a micro or small enterprises if supplies were made or contracts were executed before filing of the memorandum under Section 18. And is exactly what has been argued by Mr. Bassi. He said Shilpi is an authority that you cannot go to Arbitration Council if your contract is predates. And this is exactly what the Honorable Supreme Court says. It is not. Then Malad considers Gujarat State Civil Malad 44. That is also Malad following Shilpi. Then Malad kindly look at na Gujarat dekhai nahi to Mahakali dekhai. Gujarat Malad is dealt with. So since Malad my learned friend are not relied upon, then Malad I'm not also distinguishing that. Only Shilpi has been considered. And on that ground, Malad will find In fact, my lord, it holds. Shilpi
Paragraph 56 says those
Sub-
are not
Yes.
binding precedents. Shilpi, Mohakali, Vaishnav
Correct.
Enterprise and Nitish.
Correct.
On the issue that has arisen for consideration.
Take into account the compelling need to ensure clarity and consideration, take into account the and certainty about the applicable precedent subject, we deem it approved, refer this appeal.
This was the division bench. That is why
Yes.
making a distinction, referring it to a larger bench.
Because Shilpi was, my lord, also. আচ্ছা তো এখানে দিয়েছো Shilpi was also my lord to bench.
Yes. So that is why taking a different view refers to a.
Interprets or says Shilpi hasn't decided that.
Yes, says not binding precedent, even then it refers to a larger bench.
For the purpose of clarity, that's
Clarity has to be because two
Correct.
division bench.
So, my lord, on both grounds, therefore, my lord, both grounds, I'm saying, my lord, that in fact, that's why, my lord, section 18, because that's an interpretation of the act itself, my lord,
Yes.
the MSME Act.
MSME Act, micro, small and MS. Yes. Section 18.
Yes. First, can you see 17 for any goods supplied or services rendered by the supplier, buyer shall be liable to pay the amount with interest thereon as provided under section 16. Then 18 says, notwithstanding anything contained in any other law for the timing in force, any party to a dispute may, with regard to any amount due under section 17, may make a reference. So any party to a dispute, that's what they interpret. Saying at the time when you're making the reference, you are a.
Anything more, Mr. Banerjee?
No, I think those are our submissions. Right. And my respectful submission is this petition should be really dismissed at the threshold itself. And sorry, I just wanted to also Haryana Pradesh to the Haryana Pradesh Congress Committee. It's a 2021.
On what point?
On the ground that it will not be entertained without that 75% deposit. So that was not
I think India Glycols also clarified that.
Yes. India Glycols said goes higher. India Glycols uses that logic to say why we are not going to entertain it or not maintain it.
Yes, because it will be amounting to bypassing that statutory
Correct.
remedy.
Yeah, just for the sake of
Yes.
Okay, 2021 SCC online SC 3722. Well, it's very short judgment. Can you look at? Just give me the copy. একটা copy down. আমি আমারটা দিয়ে দিচ্ছি। Paragraph 7.
7 is the effective paragraph.
So I am saying, why should today the court really be interested in giving
Yes.
Why should today, if I put my argument, why should the court today really be interested in giving him any special remedy under 226, 227? You have contested it, you have lost on your points, and the points also appear to be a little, if I may say so, it's not as if it's free from all doubt. In fact, the law is in my favor, it goes against them. With NBCC, it goes against them.
Yes.
It clarifies saying Shilpi is not that. If that is the case, then I am true. So why?
Because that is their only point.
Yes. Yes. Otherwise, why should 227 court interfere at all? And particularly when you have not. But that is why I said 227 also has enough power. Maybe perhaps 226 court has more power than 227 in that sense. To say you deposit, then I'll hear. Let's see how much.
Yes. That line of decisions you will also get. That even 226.
226. 226 I shall get.
226.
Perhaps it will be a little. I don't know. My lord's knowledge.
The discretion of the court can impose that.
Please kindly entertain and kindly ask them to deposit 75.
226 also, under those revenue statutes, you will be finding those similar. At times, the courts direct that you deposit this amount. May not be that, may not be 75%. Court may also say yes.
Here, Mullah, there is a statutory
Yes.
provision given. And he can't, why should he avoid Mullah, the statute Mullah, when it is there? I'm sorry, Mullah, I also, Mullah, since it fell from Mullah, I think that's the Mullah, that saying, Mullah, whatever Mullah is the judgment which is prevailing is the law. Mullah, that I'm sorry, Mullah, this Mullah,
what is the cost title?
Copy on live law. Mullah, this is Rajneesh Kumar Rai versus Union of India and others. I'm so sorry, Mullah, it's live law. I'll try and get Mullah the SCC and give it to Mullah. The SCC copy.
This is that even if it is referred, the existing law which has been, that
correct,
should be.
Correct. It's 2023, give me the citation, 2023, 14 SCC 782. 14 SCC 782.
Yes.
Paragraph Mullah 4. And this is Mullah the Supreme Court considering another Supreme Court decision.
Otherwise, no matter can be decided. Has to be decided on the basis of some.
We always thought, Mullah, initially when I came referred to a larger bench, I went and said, refer to a larger bench, therefore do not decide. And what I've got then shown judgment saying that, sorry, when that comes, then we will see what the law is.
Yes.
But for at present, whatever is decided is Mullah.
That was, this issue was also decided by our court, by Justice Bhaskar Bhattacharya in Niranjan Chatterjee's matters. So when this reference of in Paschim Bongo Bhumijimi, under the Land Reforms Act, that reference was made. So from here, SLP was filed. So what would be the effect of pending SLP?
That
Says
is
no.
also
Says the binding effect of that decision does not evaporate.
Even if it is stayed, then also it doesn't go away.
It's inter parties.
Correct.
It's inter parties.
Correct.
Parties are bound.
Successfully argued that Mullah before Mullah.
But the binding effect of that judgment is not lost.
Correct.
Even merely because of the fact that the special leave petition has been filed and it has been stayed.
And stayed. Then also Mullah, it says inter-party binding.
It's an inter-party.
The law is that.
Yes. Law does not change. Yes.
My lord keeps it next Tuesday for Mr. Basu to address you.
Reply. That's next Tuesday. Kobe ache? Kobe phanka ache? After 27th. That's the
27th.
After that,
very well. 27th, the earlier matter has been fixed.
Very well, 27th.
Okay. Kobe ache?
28th to revision. 28th.
Huh? Present.
28th,
case,
Mullah, is it possible?
28th?
28th.
Chatte paka ache? 15 matter has been fixed.
27th is not possible.
27th, the other matter has been fixed.
So that may not take much.
Alimony matter, Mr. Banerjee, you know. So they will say this much and
one branch, Mullah, which I have. Earlier days, Mullah, I did, but after that, Mullah, I've tried to avoid.
Huh?
I used to pass it on to my better half.
Kobe bolna. 29th, you have difficulty.
29th, Mullah, answer.
Mallet keeps it thereafter then.
No,
September. September?
Yes.
3rd September. 3rd September.
Mullah, we are in a rush to Mullah, because Mullah, they are now going to the National Company Law Tribunal and is saying, no, this is issue pending, don't hear the matter.
That's the law.
See, only on these judgments, that's the
Very well.
difficulty.
Murder.
Because the motions have to be given precedence.
But before rising, murder, I have to interval item number 104. It's a 3 p.m. matter.
Yes.
Murder, before that matter is not taken up, I missed the matter 104.
So, keep what has been done? 104? I think
Murder.
order has been passed.
Murder.
Is that better? Expeditious hearing?
Yes. 90-35 partition suit.
Yes, I've said within 9 months, I think, to dispose of the suit.
Preliminary decree, but the commissioner report has been filed. Partition commissioner has filed his report.
Partition commissioner has filed
his report. Only the partition report has been filed. Everything has been completed.
I've said 9 months, considering that it's pending from 31.
And it is thought because partition commission report has been filed. No one challenged.
তাহলে ওই যেটা 100
ফিটে গেল
রেকর্ড করে দিন মিস্টার ঘোষের নামটা রেকর্ড করে দেবেন 9 মাস বলেছি বোধহয়
to 6 months.
Can it be considered at 510?
That is beyond.
Continuing matter, Mr. Ghosh can
then
be.
my land senior friend matter 6 at 3 p.m.
What?
3rd September. This order is also.
No, that is a fixed matter. So this was taken up prior to 4:30, continued, and you have started after 5:10.
Much of that.
Thank you.